One item, a criminal petition may be listed on 27th, Lordship. There is an order of this Honorable Court to list the matter after 2 weeks in the month of November last year, Lordship. And after paper publication, that my interim prayer would be considered. That is why, Lordship.
28, Wednesday. Okay. 27 is a hearing day, so we will not taking up.
Yes.
May I please, your
Yes.
lordship?
Just a minute. Mr. Mazumdar, come forward. The junior lawyers should make the way for the seniors.
Yes.
You must understand from the bar.
Lordship, I beg to mention two cases for listing, one for hearing, Lordship, and another for orders. Lordship.
Mr. Mazumdar, for hearing, it will not come directly. You have to bring it for the orders first, then only possible.
Then it is both the matter may come up for order. Any date, Lordship, convenient, any date.
31st.
Lord, of like.
Yes, Ms. Sharma.
My learned colleague wants to make a mention.
May I please, your lordship? With the consent of others, I beg to mention item number 4, your lordship. My senior Mr. A.K. Purkasta is not well, lordship.
My only prayer, my lord, is if a date may be fixed.
See, basically these matters are 2019. Let the matter reach, then we'll pass the order. Let the matter reach.
My lord, I may be running around, but my lord, if a date may be fixed, that's my
Difficulty is, date as if now if you go to see that it's full up to middle of the September. 9th of September.
deeply obliged.
Lordship, interim shall continue.
Then you have to reject it.
I am so grateful.
So you see from 2019,
Lordship.
and if you see the date list, how many times you have taken admission? Not you, in the name of your senior.
And the ground
further-
of this renders me absolutely speechless. It
No
is seniors.
further adjournment considering the matter of 2019, list on 9th.
Deeply obliged.
Yes, Amit.
May I please just, I beg to mention item number 16, my lord.
Hmm.
Matter may be taken up next week, my lord, anything.
On repair of the counsel for the petitioner, matter is adjourned for 2 weeks and a date to be fixed for the rest. Yes.
There is an interim order.
Next get on list.
Obvious.
May I please, lordship, I beg to mention criminal revision petition 102 for withdrawal. Matter may be listed tomorrow.
I go Kali. I- Clear level, so he wishes again. 102 of which year?
2024.
Okay, we'll see.
May I please, your lordship? Lordship, with the consent of the others, I beg to mention item number 42 of the daily list, lordship. Lordship, Argun Council, Mr. R. has some personal difficulty today, lordship. Lordship, kindly take up this matter on next week, lordship.
These are order matters.
Yes, lordship.
Let somebody here,
I have already taken consent, lordship.
maybe. Let the matter be here, because these are in order matters, so we have to verify.
44.
Let it reach, we'll pass the order, we'll adjourn it, no doubt, but let the matter reach. Yes,
May please, your lordship. I beg to mention for listing, my lord, the orders matter, my lord, next week, my lord, any date, my lord, next week.
thirtieth, 30.
Three
Yes,
zero.
yes, some of you come this side.
May I please, your lordship, I beg to mention item 21 of the daily list. CD is not available.
How do you know?
Confirm it with the PP.
She asked me, CD is not here with me now, but it might be in the office. I have to check.
It has to come from which police station? See, you are not.
51, the petition copy is here. CD perhaps is not there.
Can you verify and let us know? Yes.
May I pray before worship? I pray before worship for listing a orders matter against who is washing petition, my lord, and as per instruction services complete. And on 27, my lord, lawyer could income room metro this case is fixed for evidence, my lord, against which I come before you, my lord. Maybe
Why you have make it mention today when there are 4 days holiday? You could have make it mention earlier.
my lord, for service completion.
That is why you could have mentioned it. You cannot ask make a mention today and have it for 27th. 28. Yes, make it on 28.
Must.
Yes.
Your lordship, similar prayer.
What is similar prayer?
Your lordship, petition for quashing matter is fixed on 27th, your lordship.
Why?
For-
Why it should be listed on 27? It's a hearing day,
Yes, your lordship.
so 29, 3830.
Obligation.
Yes.
May I present, Lordship, I beg to mention for listing, Lordship. Lordship,
Listing for what, sir?
Lordship, quashing FIR, Lordship,
For orders and.
for orders, Lordship. Lordship, this item was last time is in listed 14/8/2024, Lordship. Lordship, but this matter was left over, Lordship.
Okay, on 3830.
Obliged,
Yes.
Lordship.
May I please your lordship, lordship, I beg to mention item number 11. My learned senior counsel, Mr. D Nandi, for an urgent prefixed matter here to go to Meghalaya High Court. As such, he will not be able to attend the matter.
Mr. Chair,
There, madam. Already they have taken the consent, madam.
second.
Deeply obliged. Deeply obliged.
May I
Yes.
please, your Lordship? Lordship, I am praying for listing of a criminal petition for orders, Lordship. May I please, your Lordship, can I take up the 30th or 31st, Lordship?
Second.
Obliged. May I please, your Lordship, I mention for upgradation, Lordship.
Item
Item number 45, Lordship. Just implement the petition, Lordship. Implement the name, respondent name.
We'll take it up sometime in second half, around 3 and all. What is that police case? From which police station? Ms. Ram? Got it from which police station? 21? Burwa, file to do.
So on this way.
Let us see.
Question is that Lordship, already informer is died.
Just a minute, just a minute.
Informant in the case, yeah. Who decided?
না না একটু মানে একটু পেশে দিয়ে অবজেকশন দিয়ে কাটিয়ে দিতে এই পিস অফ কাটিয়ে দিতে তার মানে না তো কোর্টে না না একটু দিব
It don't any decided.
আপনি এই মধ্যে লিগাল হিয়ার না এই বেলে এটা ট্রিটমেন্ট
Implement of the victim. কি হয় এটা?
এই ভিডিও নাম
আমার দুজন নামে আছে এটা। আমি বলছি,
ইয়াতে আসছে
এটা তোমার কি দিল? পাওয়া নেই। এনে দিবনে নিয়ে দিলে পেয়েও সম্ভব আছে। কনভিকশন হয়েছে স্যার,
প্রভিশন হিসেবে রিপিট
319
এটা তো ইমপ্লিমেন্ট না লাগে
জাজমেন্ট হয়ে গেল তখন। না না দেয় না কি বলে এটা 45 হুম
Have you seen the order, ma'am?
Lordship, yes,
Have
26
you seen
nine.
how your IO is working?
Lordship, that I have yet to notice on
If you read the order itself, the impugn order.
26 9, I'm,
Yes.
yes.
The
Uh,
prosecution witnesses, the records reveals, in spite of that, the IO has acted that manner.
Acha. At
Take
least
action, take
26.
action,
Lordship.
whoever it is, or we'll call for the records.
Lordship, 1, 2, and 5. And there evidence the involvement of the FIR named accused Ahaduddin. And the person was not called upon to appear before this court by the prosecution.
Mr. Adamji, thing is this, there are two applications, one for imprisonment. And others,
Delay lordship.
this criminal revision petition has not yet been admitted. Why it has come for admission?
But the question is that delay, I just come from delay.
His name was also there in the FIR.
Yes.
It's not that his name cropped up
No, that's the
later.
reason we want to know.
But
Lordship.
Chassis his name is not there, lordship.
That is the reason, that is the IO,
That is the
161 statement reveals that as per the report of the assistant session judge.
Everyone, especially 1, 2, and 5 had named.
Yeah, Burwa.
Good number of witnesses are implicated.
Immediately খবর করো দেখি admission of QIC. Sure, 21. This is the picture. Anyway, later matter reach, we'll pass
Lordship.
order. We'll upgrade it at 2, evening afternoon meeting. What about the item 21?
21 case diary is not here. We have not received. 21? No. Oh, 21. Ah, cover good. Okay, I'll do that.
লেখা আছে। By order dated 21/06/2024. Case diary relating to Dispur Police Station case number 165/2024 was called for. When the matter was taken up today for consideration on being inquired, Ms. Jahan submitted that the records of the said case diary is yet to be received. In view of the above, raise this matter on 28/08/2024. For production of the said case diary pertaining to Dispur PS case number, up to the case diary pertaining to Dispur PS case number 165/2024, failing which the investigating officer, the said police, the case shall personally even present before this court. As this order has been passed in presence of MSS Jahan Land Edition for the prosecutor, no formal notice or information need to be provided concerning investigating officer of said Dispur PS case. List accordingly.
That's.
Please, Your Worship. And we are listing a bail application, AB application. It was last posted on highway 24. And then is it number next week 27?
It's not possible, ma'am, on 27.
Can it be done?
It will come for orders.
Anticipatory bail, ma'am. Anticipatory bail.
Anticipatory bail before this court, why?
Rejected by your lordship.
This is senior bench, that's the thing.
28.
Obliged, ma'am.
The appropriate court of the
Petition. Someone good documents.
Please, Your Lord. This is the anticipatory bail application, my lord. FIR is at page number 13, my lord. Allegation of missing cow, my lord. Here the petitioner is the president of the Gaushala, my lord. Page number 13 is the FIR, my lord.
Ms. Jahan,
No, Chief.
first of all, come to page number 17.
No, Chief. Yes, I've seen the report.
That is a report of 11th of January 2023.
Hmm.
There, the finding is 20 number of buffaloes
Hmm.
and 70 numbers of cows,
Hmm.
total 90.
Hmm. Otherwise, neat and clean in maximum
Now-
capacity, yes.
Please come to page number 18.
Hmm. Yes,
Serial number 3 down below.
Rashtriya Goshala, yes,
Same,
369.
where from?
Hmm. Otherwise, what they say is that.
It is 20 plus 70. Now here it is without any signature, of course,
Hmm.
48 plus 321.
Hmm. Then. I don't
That
know.
is a report of 20th of January.
Ah.
Get the information from the concerned officer. He is sub-inspector.
Hmm. Otherwise, this calculation is wrong.
Get the information and let us know by
Huh. In
20
fact, in each,
29th.
the calculation is wrong in respect of each of the columns.
Exactly.
Each-
So that is what the difference is you have seen.
Huh.
Page 3, at page 17,
Hmm.
serial number 3, it gives a different finding.
Hmm.
And then that down below at page 18, it gives a different finding.
Hmm.
So get the information
Gotcha.
and we'll by 29th.
Hmm.
Okay,
Gotcha.
No, the interim protection may be granted, my lord.
till 29th. Wait for some time.
Because, my lord, I have annexed the sum of the.
We'll consider your prayer, don't worry. List on 29th. And I'm only a message on. Not additional public prosecutor. To place the up-to-date report. Regarding the number of kettles. Available at Rashtriya Goshala, Tangna Mari, under Suksur Police Station,
Yes, my lord.
Hmm.
Suksur Police Station. Of Mankasa District. South Salmon, Mankasa District.
The police is now behind me, my lord, after 1 year. Initially, they arrested the secretary, my
You
lord.
have it looking. May I please proceed? Yes, there is a direction. Ms. Zahan, officer in charge of Silchar Police Station to submit a detailed report. Present status of Silchar PS case number 2314/2018.
Yes, sir. Was perhaps not there, I mean. Mr. D Das was there. I'll inquire what happened with Mr. D Das.
List on 38. Enabling The concerned investigating officer of Silchar, the concerned officer in charge as well as the investigating officer of Silchar Police Station case number to submit the up-to-date status relating to Silchar Police Station case number 2314/2018 corresponding to GR number 3552/2018. Relating to the age of the victim girl. Has been directed earlier by order dated 22/07/2024, failing which the concerned officer in charge of Silchar Police Station as well as reason have to personally remain present before the court on the same date. Much of the.
In three also, I was supposed to bring the instruction as to what happened in the case. Lordship, I have sent Mr. Sharma to get the information whether they have received something. Let the matter come up tomorrow or day after.
If you have received, fine.
Lordship,
If you have not received, similar order
Lordship,
on 30th,
Lordship.
failing which the officer in charge of Bholai Police Station, given officer in charge of Bholai Police Station as well as the concerned investigating officer. Bholai Police Station case number 466/2017 has to personally remain present in terms of the earlier order dated 22/07/2022. But the law will need to be, since this order has been passed, presence of no formal notice need to be issued. Copy of the order that will do. Copy of something that will also, for the necessary. We'll pop it at 2 o'clock.
Lordship, matter may be taken up after some time. My senior is on next.
You have the case diary? Malik. Instead of scan the case diary itself has come.
Summer 6 to 9. 6 to 9.
6.
Sunday, I'm at.
Yes, Mr. Hazarika, what do you have to say?
Well, this petition is filed for quashing of the FIR initially, my
Why?
lord.
Why should?
My lord,
Cost.
because at first, my lord, although the government land, they have been in possession for the one social or cultural organization was set up by the petitioner.
Show us your registration.
My lord,
Show us your registration.
but
Where you paid before the government for that land. Show us your application before the government. When did you file that application?
before that, my lord,
Kindly show us, Mr. Hazarika, first.
22, I have updated one. The circle officer's report is there, my lord.
You
In
have
this
seen,
regard.
it's a
and-
government, you have seen the circle officer's report, it's
Yes,
a
sir.
government land. And where did your application, where it was considered?
But in any case, but the title suit is also pending, my lord. Let me kindly.
Whatever, we are not on that. Now just tell us,
But
Where is your application?
they have
for
been
the
also
government?
paying,
Why the government considered? And show us your registration.
but it is pending maybe, Madam.
You are not on that. You may file hundreds and thousands of suits, but this is a government land that is
That is-
apparent from the report of the circle officer. Where is your application and where is your registration?
That will be, look, the title suit is pending, my lord.
That is not,
But-
cannot be. You
I
are
mean-
occupying the government land.
No, that, because the reason they given by the respondent to is that for construction, but that is already over in
Whatever
2020.
construction after. all,
And
it's a
now it
government
is
land.
stale, my lord, only. And title suit is pending where the. court
Maybe we
has
will not
to-
interfere. We'll reject
That's-
this.
My lord, kind of pending.
You
Kind
will
of.
dismiss it, that's
Now,
all.
apart from that, my
You
lord, this
cannot
proceeding
enforce
is
like
under,
this.
my lord.
In the name of some organization, you just simply cannot enter in a government
Plus,
land.
actually, this
Where is
case,
your registration and application before the
then I have
government?
to take instruction, but can you give me some
Okay.
time, my lord?
That is, you will not have a second sentence.
Because I have to look.
Not
into-
Mr. Rai Hazarika. counsel
Kindly give
speaking
my
for the
one,
petitioner.
only with one.
Show us any material,
That is,
show us,
that, my lord.
which is in your application.
Because at page 22, one Salan, they have said, they have next one, we can payment of it.
Yes.
At page 23, my lord. Because this proceeding should be before the special tribunal.
Whatever,
before that
will absolutely be there, don't worry.
My lord, that, but it is before the additional chief judicial magistrate, which is not maintainable, my lord, because proceeding itself is not maintainable, because barred by the act, man, itself.
We'll do that.
Yes, but I kindly look in that manner. That part will I looked in, man. Because title suit is also pending in this matter, man.
That is, you will always be doing it, entering into government land, then you will file a
No,
title.
another person has also applied, that applied, my lord, and
Where
it's
is
the copy
that?
of
What do
that
you want to show,
application.
Mr. Hazarika?
But at page 23, my
Mr.
lord,
Hazarika, what do you want to show?
my lord, at page 23, my lord, there is an vernacular that Salan regarding a tax paid by the petitioners organized club, my lord.
Now, you are aware,
My lord,
you are aware
yes, my lord.
how this tax to be paid,
Yes, my lord.
in what manner? In a government land, how will you be able to pay tax? Where is your authority to enter the government land?
No, tax, but they have to
Where is
pay-
your authority to enter into the government land?
they
Mr.
have-
Hazarika,
They have applied, my lord.
you enter into Just field, Lotus Hill field.
No, that is.
No,
not
tell
that.
us.
Question- it
Tell
was
us, where is your?
Only
let
because
us
somebody has
assume-
applied, my lord. Another person has applied.
Might have
and we-
applied, might have applied.
That is the
You
reason.
also applied. Where is the harm? There is no bar for your application. You apply. When did you apply?
No, that record I have to,
Mr.
the title suit is pending in this regard, my lord.
Maybe.
But that.
We'll
can I-
pass the order.
Then another,
Quickly
part-
dismissed, we'll pass the order.
but in the meantime, let me another date may kindly fix, my lord, otherwise, my lord, because it is proceeding itself is barred, my lord, already.
We know that. We'll pass the necessary
As per
order.
section 7 of the Assam Land Grabbing Act
We'll do
provision.
that.
Proceeding
that.
itself is barred, my lord. So that will look.
Lord
that will-
Mr. Ayazidika, counsel appearing for the petitioner.
And they have come belatedly also, my lord, now, my lord. It was there already, my lord.
Mr. Petitioner. B. Sharma, an additional public prosecutor. Appearing for the state. Who is any government advocate here? No, man. Any standing counsel for the PWD? Ask Mr. B. Gogoi.
And he is also not the authority also, my lord, who has lost the affair, my
Don't
lord.
worry.
He's a revenue
We'll
authority,
take care
he
of
is the authority, my lord, you know.
We'll take care of that, don't worry. Dismissed, Balika. Mr. Sharma has placed the scan copy of the records of Karimganj Police Station case number 39/2020. Registered under section 120B/447/420/34 IPC, reduced section 4 within bracket 2, within bracket 5 within bracket n. Small of the Land Grabbing Act. Let it go. Dismissed. Interim order passed earlier on 27/01/2020 stands vacated. In view of the order passed today, and the criminal petition number such and such, the connected I being in flux was stands dismissed. At a point, Likito failed to post any registration of the association. Next,
Regarding that matter, my lord, manner, tribunal, my lord, that may observe, my lord, kind of.
we'll do that, don't worry. Already the sections are under Land Grabbing Act.
Because the tribunals which you look into, maybe, district and session judge is the author, proper forum, my lord, not the additional chief, my lord.
It will be under the Land Grabbing Act. The matter
It is taken up by the additional chief judicial magistrate, my lord. That is the bar, my lord.
will definitely do that.
May I please have a- In this case, during the lockdown period, this matter was filed also. So I am paying for the, as part of the matter to the regular bench law. The initially interim order was passed, subject to condition that 8 lakh we have to require to deposit lordship. That was not deposited, and that's why the interim order was vacated by order dated 21/6/2023. Subsequently, we have paid deposited 5 lakhs rupees lordship out of the 8 lakhs rupees. The petitioner was. We have.
You have not complied with the court's order?
Yes, lordship.
No,
You have
Lordship,
not
they
complied.
are yet
But
to pay
5
3
lakhs,
lakh
5 lakhs we have paid lordship, and for
What are the direction?
initially 8 lakhs lordship.
What are the direction by the court?
24/3/2020 order lordship,
How much to be paid?
8 lakhs,
How much you have paid?
5 lakhs.
Have you paid before the court?
Yes, lordship. We have paid.
For any such alteration?
I think they have also.
Have you paid before the court?
Lordship.
Direction of this court was rupees 8 lakhs.
Yes, lordship.
You have paid 5 lakhs.
5 lakhs. Yes.
Can you do that?
Lordship, no, lordship, but we are paying for some time for depositing
Can you
the.
grant it now?
Lordship,
When this order was passed?
lordship, order was passed on 24/3/2020.
And today is,
Lordship, we have
Today
submitted,
is-
we have submitted lordship,
Mr. Kulta, today is, what is the date today?
21, lordship, 21/8.
So we will dismiss it.
Lordship,
You have
we
not
have-
complied with the court order.
Lordship, we have submitted the.
Mr.
Lordship,
Kalita,
lordship,
just
this-
tell us one thing.
lordship,
On the
this-
direction of the court is that,
Lordship,
where is your
lordship-
application?
Lordship, subsequently, this honorable court has granted several opportunities, lordship.
Well,
Lordship,
that is
lordship,
why-
lordship may kindly peruse the order. Lordship,
Mr.
43/2024, lordship, the
tell us
imputation was done.
On which date this order of 24th of
Lordship,
March
lordship,
2020
lordship,
was modified?
Lordship, they are,
Kindly tell us that
No,
date
lordship.
on which was modified.
the interim order was vacated, lordship. Interim order was vacated, but petitioner was hospitalized for around 2 years, lordship.
Mr. Kalita, we are asking you something, you are answering something else. When this order of 24th of March of 2020 was modified?
No, not more.
It was not modified.
I've.
But
lordship,
Mr.
lordship,
Kalita,
but
counsel
lordship,
appearing for the
lordship may
petition.
consider one prayer, lordship. Lordship, we have submitted the hospital, he was hospitalized for 2 years, lordship. Yes,
Mr.
imputation was done. Lordship.
Kalita, you are an experienced lawyer. You are not a novice that you have joined yesterday.
No.
Right? So you know what to do.
Lordship,
By order is the
the-
24/03/2020.
Lordship, that's why, lordship, I am paying for last one chance, lordship.
How many census were given by the court earlier?
Lordship, I fairly submitted, lordship, considering my prayer, lordship, this honorable court has granted, and accordingly, last
Not
occasion,
your order, not required to be heard. While considering the prayer of the petitioner in this petition. Okay. Let me go. Heard Mr. K. Kalita, learned counsel appearing for the petition. Now, Chief Judicial Magistrate cum Civil Judge Senior Division. UPR, Papum Pare. District, Arunachal Pradesh. In CR case number 872015. On the basis of a complaint petition filed by the respondent number 1 under section 138 of the NI Act 1881, convicted the petitioner under section 138 of the NI Act 1881 and sentenced him to undergo simple imprisonment for 6 months and to pay compensation of rupees 32 lakhs. In default to pay compensation to undergo simple imprisonment for 3 months. Again, we say the order of the learned Susan cum Civil Judge Senior Division APR. Dated 09/09/2019. That will be seen over. The petitioner preferred an appeal before the learned Session Judge UPR. Papumpari being criminal appeal number 11/2019. After hearing the parties, by order dated 05/03/2020, the learned Session Judge UPR, Papumpare district, Arunachal Pradesh. Dismissed the said criminal appeal of the petition, number appeal number 11/2019 of the petition, upholding order of the London Susan from Civil Justice Division, UPR, dated 09/09/2019, noted above. Thereafter, the petitioner, during the COVID period, filed this criminal revision petition in the principal seat of the Guwahati High Court. Being allowed by his lordship, Honorable Chief Justice, and his administrative side. This court by order dated 24/03/2020. While issuing notice to the respondents hearing, in the interim, passed a conditional stay of the said judgment dated 05/03/2020. Passed by London Sessions Judge UPR, Papumpare, dismissing the criminal appeal number 11/2019. Directing the petitioner to deposit 25% of the compensation amount of rupees 32 lakhs, amounting to rupees 8 lakhs, before the registry of this court on or before the next returnable date, dated 08/05/2020. With the observation that till the next returnable date, the sentence passed against the petitioner by the Land Trial Court in CR case number 87/2015, as affirmed by the appellate court in criminal number 11/2019, common noted above, shall remain still. Pursuant to the said order of the court, dated 24/03/2020, the petitioner on 19/08/2024 deposited an amount of rupees 5 lakh with the Registrar General of this High Court
25/6 lakhs.
on 25/06/2020. It is contended by the petition that it is contended on behalf of the petitioner. The petitioner was under medical treatment and hospitalized for about a period of 2 years. Full stop. We have seen from the order 6 of this revision petition that on 11/5/2020, 01/02/2021, 29/05/2023, court adjourned the matter on the prayer of the petitioner, extending the interim order dated 24/03/2020. By order dated 29/05/2023, the court directed the petition to deposit the said amount of rupees 8 lakh being 25% of the compensation amount of rupees 32 lakhs before the registry positively by 21/06/2023. Observing that failing on its part, the interim order is 24/03/2000 will be cancelled. On 21/06/2023, the court indicated that the petitioner failed to deposit rupees 8 lakh being annual, and the interim order dated 24/03/2020 was cancelled. Directed list the matter after 4 weeks for payment of rupees 8 lakh. On 19/03/2024, considering the health condition of the petitioner has been submitted before the court, the petitioner was given the last chance to deposit the said amount of rupees 8 lakh, which he did not pay. Fixing the matter 03/05/2024, and the petitioner did not pay the said amount. On 03/05/2024, it was submitted by the petitioner before the court that he is ready to pay the interim compensation amount of rupees 8 lakh as per the direction of the court dated 24/03/2020 after 6th June 2020, which was recorded in the order. Accordingly, matter was fixed on 25/06/2024. On 25/06/2024, the petitioner, in spite of his submission dated 03/05/2024 and has been recorded by the court, deposited only 5 lakhs of rupees with the registry of this court. The court directed the registry to release they could allow the respondent number 1 to withdraw the said amount of rupees 5 lakhs and directed the petitioner to pay the remaining amount of rupees 3 lakhs to the respondent, directing it to release the matter on 12/8/2023. On 12/8/2024, the matter was listed in the adjourned on the prayer of the council for the petitioner. Today, on being inquired, Mr. Kalida submitted that the petitioner is yet to deposit the remaining amount of rupees 3 lakh. Since the order of the courts have not yet been, as the orders of the courts noted above have not yet been complied with by the petitioner, this criminal division petition being devoid of merit stands dismissed.
Not only recorded medical certificate.
Next. Next thing is without seeking any intent from the spirit. Yes, Mr. Bora.
My lord, decision, we are against the impugn order, my lord, page 32.
Yes.
What happened, my lord, in this case, a complaint petition, complaint case has been initiated against the petitioners and the others regarding the falsification of the some documents regarding the purchase of the land. Now, the court has taken cognizance of this case under 468 of the CRPC, which is in a warrant procedure case. Now, the trial court, and we have filed a petition after appearing for the discharge of the petitioner, my lord. And the trial court, on being satisfied, but they rejected my petition only on the ground on a misconception of the law that the court doesn't have the power to discharge the petitioner because of he has taken the cognizance already, madam. That isn't, this is the procedural because of the bar. Once the cognizance is taken, he can't go back and discharge the petitioner, my lord. Otherwise, the court was convinced prima facie that the complainant has failed to show prima facie case against the petitioner because the dark numbers of the
Yes,
respect
Mr. Chaudhary.
but and the
What do you have to say?
My lord, that document, my lord, we have got that document. That the complainant has no land in patta number 1 and DAG number 482, what that has been, my lord, reflected in this order. But we are a bona fide purchaser, my lord, of that, and we have got a document of for that also.
But
and all these things will come, my lord, while my
With
lord.
the evidence.
no, the debt has to be first pleaded in the complaint case, madam. And in the complaint case, the subsequent document, that's not a procedure, my lord. While the petition, the discharge application is filed, the court has to see what are the material available on that particular day, whether the prima facie case made out or not, on the basis of the complaint and the annexes, if any. Court cannot, on the basis of the anticipatory evidence that tomorrow some more material will come or tomorrow the complainant submit the bond document, court cannot frame the charge. Court has to rely on the document based on the material on that day. The court, as per the order, on that particular day, there is no such material before the court. So my contention is that, as per the law and the judgment is concerned, court has very much has the power to discharge the application on the basis of the material on that day. So my case is that let the court decide afresh on the basis of the material. Available on record. It's because
What is the
court,
complaint petition?
the complaint petition is that at page, my lord, 15 onwards, my lord. It starts from page 20.
Just take Ms. Jahan. See, there is a specific report before the learned magistrate that the particular patta contains only 27 bighas.
Hmm.
It's very specific report and on evidence from the record. But sale deed was made instead of 27, 77.
Sale deed is made of
77 bighas.
Se-
Altogether,
seven-
there are 77, but
That's right.
the land in that particular content, that's what's already record.
27.
27. That 27 has become 77. That's the issue raised by the complainants. Go through it and tell us.
Not,
Tell us on Tuesday.
not.
Go to the
Not
record.
gone. Yes.
We have marked 2, 3 portions.
Mhm.
And the official record reveals, even the records are there. Both the 77,
Cannot
which
be.
is said to be fake, forged in fact, and the original 27. Go to the record.
Yeah, the,
Either on 27th or 29th, whichever they pick. Tell us.
my lord, just I want to point out one thing, my lord. Lordship will kindly come to my lord
But
page.
the issue here is that the learned magistrate wanted since taking cognizance of the offense, saying that cannot discharge at that stage. But on that ground, that is a different issue altogether. But thing is what we found from the records of the case, that in that particular DUG 480, there is only 27 bighas.
But that issue probably, my lord, whether it was before the complaint case and the initial deposition.
No,
That-
record was produced before the learned magistrate.
My lord, that record, whether he has taken the cognizance, my lord, without going to the evidence, whether that record can be considered.
It was,
That will be a different
it was not
aspect.
at the behest of the complainant, it was on the court to
No,
verify that
if-
it was. false.
no, that's not the procedure. That can't be the procedure of the CRPC. That can't be the procedure. It is the complaint case. On the basis of the complaint and the annexure, the cognizance has to be taken and the process will go accordingly. That
In
matter is
the
a different
complaint-
matter.
In the complaint, what we have found is that the complainant has obtained this on the basis of RTI.
Yes,
Initially, it was
but
given.
that
different things.
document is not annexed, my lord.
RTI, he has made a mention.
Yes, but that is not,
Mention, and then RTI has only often getting the information through RTI, he could collect it. That is why he said his report 27 to 77.
no, that's a different aspect altogether, my lord. That's not the case here, my lord. My case is that whatever the allegation has been made,
Anyway, we'll come back to on 27 to
my lord,
29.
27, I may not be there, my lord,
On 29th.
on 29.
Okay.
How well, lordship.
Nine charge sheet is submitted.
Oh, let us see.
Case diary was called for, but charge sheet is submitted. Jimma. Oh, Jimma. I thought they have challenged the FIR.
See, please come to the finding of the learned. It's very
25,
clear.
422.
Yes.
Page 20, lord.
Hmm. And what they have said is, report is submitted. Yes, there is a,
Specific provision for transfer of cattle. Right?
there is a violation
That
of
is
the,
that a violation.
in fact, transportation of cattle, there should not be more than 6 cattle on a particular
Now, Of
vehicle.
course, as per this report, there is requirements of permission. Is there.
Yes, they could not show the permission as well.
That's right.
So, Lordship, my submission is that, Lordship, the Assam Cattle Preservation Act, the Lordship, may kindly see section 7, Lordship. Section 7, subsection 6, clause 2, Lordship.
শর্মা, এই ইয়াতে উল্লেখ হৈছিল। ওলাইছে।
section 7 subsection 6 clause 2 লচিত
এখন yes
yes lordship is goes also the married lordship section 7 subsection 6 clause 2 lordship
section 7
section 7 subsection 6 clause 2 lordship
of which act?
Assam Cattle Preservation Act lordship Assam Cattle Preservation Act 2021 lordship
Just
yes married lordship
just reservation rules 22 we are talking about.
no Assam Cattle Preservation Act 2021 main act lordship the Assam Cattle Preservation Act 2021 lordship section 7 subsection 6 clause 2 lordship
Yes.
married lordship so no permission shall be required for carrying cattle to and from registered animal market for the purpose of sale and purchase of such cattle within the state lordship now there is an exception lordship exception provided that such exception shall be subject to the restriction provided in subsection 3 of section 7 if your lordship go to the section 7 subsection 3 listen kindly see that goes that no person shall transport or offer for transport or cause to be transported any cattle from any place within the state of Assam to any other place in a district within the state which shares international border with any foreign country that shall
Just a minute.
slaughter whereof
Just a minute.
yeah.
Section 7 you are talking about.
Yes, section 7 subsection 3 there is an exception lordship the cattle cannot be transported those district lordship where the international border is sharing lordship otherwise then no permission is required.
No,
Right.
no permission from and
Where are you
to a
reading?
market,
Lordship.
to and from
This book
a
doesn't have
market.
section 7, 1, 2 and 3.
Well, also, section 7 subsection 3 no person shall transport or offer for transport or cause to be transported any cattle from any place within the state of Assam.
Just a minute, because this book given to us doesn't have this provision. From the site.
যদি district international border sharing করে
No,
তাহলে permission লাগে।
international border,
Sharing করে তাহলে permission লাগে।
you have to Golaghat to Nagaon, international.
no,
মই তোমাক প্ৰথমটোৱে কৈছো, except it is to and from animal market.
এখন কোনে
Animal
publish কৰিছে?
market ৰ কথাটো ইয়াত নাই নহয়।
আছে, কিন্তু
Library
library
পৰা cancel কৰাব
market,
লাগিব।
animal market খন লিখিছে নহয়।
Animal market
Sell
FIR
person
খনত
কাৰণে
ক'ত আছে? এইটো গোলাঘাট to নগাঁও, animal market লৈ যোৱা কথা নাই ন?
মানে এইটো মই restrict খন দিছো না মই। চাওক, এইখন লিখিম। Page number 23 চাওক। Page number 23
23?
এইটো।
এইটো-
গোলাঘাটৰ পৰা কিনিছো মই।
কিন্তু এনিমেল মাৰ্কেট ক'ত আছে?
এইটো বিহৰ হাতত পহু বিক্ৰী বজাৰ।
আৰু কলৈ লৈ গৈ আছে?
নগাঁও লাইন আছে মই।
নগাঁৱৰ মাৰ্কেটখন ক'ত?
নগাঁও মাৰ্কেট নহয়, মই বস্তু
কি?
বজাৰত কিনিব পাৰোঁ।
নহয়, to and from, চোৱা। To and from, দুইটা।
এই লাইব্ৰেৰী মানুহ মাতক।
গ্ৰেজিং ফিল্ড নালাগে।
ঘৰলৈ আনিব পাৰোঁ কিনি কিনি বজাৰৰ পৰা। মই গেজেট লৈ আনিব পাৰোঁ।
সেইটো দেখুৱাব লাগিব।
মই দেখুৱাই আছোঁ।
Yes, section 7, subsection 3.
Section 3 lordships. Here's lordship, section 3, no person shall be transported or offer for transported or caused to be transported any cattle from any place within the state of Assam to any.
Just a minute. That is relates to prohibition and transfer of, right?
Yes, lordship. Meaning thereby, lordships, the cattle
পূৰ্ব Kindly read 1, 2, 3.
One to section 7 logic.
Hmm.
Section. Then no person shall transport or for transport or cause to be transported any cattle without valid permission from clause 1, any place of the other state through Assam to any place outside the state of Assam. Logic. Number 1. Clause 2 logic, any place within the state of Assam to any place outside the state of Assam where slaughter of cattle is not regulated by law. That's one logic. Number 2, no person shall transport or for transport or cause to be transported any cattle from any place of the other state to any place within the state. The slaughter whereof is punishable under this act. If the cattle is purchased from the outside the state lordship, then cattle cannot be brought to the Assam lordship. That section says like that lordship. And section 3 lordship, section 3 says that the permission shall be required if the cattle.
Kindly read.
No person shall be transported or offer for transport or cause to be transported any cattle from any place within the state of Assam to any other place in a district within the state which shares international border within any foreign country. The slaughter whereof is punishable under this act. Meaning that the cattle cannot be transported to those districts where international border is sharing lordship.
Then next. Read 4.
4. In spite of notwithstanding anything contained in subsection 1, 2 and 3, the competent authority may issue permit to any agency or farm registered under the Animal Husbandry and Veterinary Department, Assam, for transport of cattle for bona fide agricultural or animal husbandry purposes or for transportation of cattle for trade for the said purposes as may be prescribed in the rules framed under this act.
Now read 5.
The cattle shall be transported in the manner prescribed by the central government rules governing the transport of cattle under the Prevention of Cruelty to Animals Act 1960.
Now tell us what is the provision? Because
Now,
only under that provision.
Suppose they have violated this rule.
Tell us.
The
What is the
prevention,
provision under the central government rule
the
for
prevention of,
transportation?
yes, Lordship. Transport of animal rules, Lordships. Yes, Lordship, may kindly see Rule 50, Lordship. Transport of animal rule, 1978, Rule 50, Lordship.
Rule 2001.
The transport of animals rule, 1978, Rule 50, Lordship.
Transport of difficulty, madam. Transportation of cattle rules.
Yeah, the transport of animal rules, 1978. Lordship.
You said rule 50?
Rule 50 Lordship. Rule 50 says that up to 200 kg of the kettle Lordship, space provided on 1 square meter Lordship. There is a chart Lordship.
A50 rule.
Yes. Rule 50 you're talking.
Yes, Rule 50, there is a chart Lordship. If the kettle is up to 200 kg above Lordship, up to 200 kg, then 1 square meter may be provided Lordship. That's a said rule Lordship. Suppose they have violated that said rule Lordship, the punishment will be Lordship, section 11 of the Prevention of Cruelty to Animals Act, 1960 Lordship. The 50 rupees fine Lordship. Section 11 of the Prevention of Cruelty to Animals Act, 1960 Lordship. Now I'm praying for the Jimma Lordship. Jimma Lordship, the Honorable Supreme Court has already decided Lordship in manager principal case I have annexed in my petition Lordship. Your Lordship may kindly see the page 40 of my petition Lordship. Supreme Court, Honorable Supreme Court judgment Lordship, page 40.
From head to tail, what is the length of a cow, normal cow?
Normally, Lordship,
Available
in Assam, Lordship, the cattle, maximum weight of the cattle in Assam
Just
is
tell us,
180 kg. Lordship.
just tell us one thing. What is the length of a cow, normal in Assam? Because Assam, the health of Assam cow is different than that of the other parts of the country, has been already observed by
Lordship.
Bapuji, right? While visiting Assam in those days itself. Now tell us what is the length of a cow?
Length should be more than 1 meter. Lordship.
More than 1 meter.
More than 1 meter.
What is the rule says?
Rule says the one scooter may be provided to one cattle Lordship, up to 200 kg. Lordship.
So normally a cow will weight above 200 kg.
No,
It's not a calf I'm talking about.
Lordship.
We're talking about a cow,
Lordship.
right? 1 square meter, you are saying the cow's length is more than 1 meter. Normal.
Normal.
But a cow less within 200 kg is having 1 square meter.
Lordship. No, that issue will be decided by the Lana trial court. Lordship. I am paying for the Jimma only. Lordship. And for the Jimma Lordship, the manager principal case Honorable Supreme Court has decided in Lordship, in paragraph 10, Lordship, I have annexed in the petition, Lordship.
Yes, Ms. Jahan, just see this order.
Lordship, I have gone through the order.
Yes, 40.
Violation, I think there is, because although he has placed section 50 in the animal, in our state rule, I think more than 6 cows one cannot transport in one particular vehicle. That is given in Assam prevention of, Assam, no, Assam. Assam, there I think 6 cows are the maximum. He has carried 31 cows. This is section 7.
It will be ruled.
It will be in the rules. It will be in the rules.
The Assam Cattle Preservation Act has already referred to the Central Act, Lordship. That is transportation rule. The transportation rule will override the.
That of course will not be, then we'll have to have presidential assent. That is not the issue here. Hey, Sota Guru hai nibo pare to etu ki ase rule to? Sota Guru hai nibo pare ase?
Itu central khana das.
No, rules come to us, sir. Sota Guru hai. No, it's in the rules.
Cruelty against
No, gari juk to ma dekhiso. 6 cattle they cannot take more than 6 cattle. It was. So what's Assam Act. I remember. I have seen it. I have placed it a number of times now. Today I've forgotten.
But our Honorable High Court has already decided, Lordship, that the owner of the cattle shall be given Jimma Lordship in principal laid down in the manager principal case, Lordship.
Now, there in the Pinjabul case, so many conditions are given when a custody can be given to the owner on production of proper documents. Hey, very good as a family of he knows. We transportation to Kopa Dahasala. Transportation Yapa Kopa Dahasala 7. Provision of transport in প্ৰথমতে ক'ত আছে মই উলিয়াই লওঁ। Lordship will take it up tomorrow, day after I'll place it.
No, some amendments are there in 2022.
Perhaps I have seen there. And moreover, the sections that he has placed, the exception to section 7, there it is said, if it is brought from and to an animal market, then only the exception will come. And this international boundary exception is again a proviso to that exception. Here is a case he has transported from Gwalpara to Nagaon, Golaghat to Nagaon, Golaghat to Nagaon, without any documents and all.
I have annexed the document, Lordship, at page 23.
Without showing that it was taken to a animal market. And moreover, that 6 cows.
These issues have already been decided by this Honorable Court, Lordship. Recently, I have annexed the order, Lordship.
Central transportation, no? Transportation of animal rules, no? Otherwise, chat shows the demand square meter, forget it. Into a sota kettle as it. Sota.
Please do one thing, get the
Lord-
information, we'll have it on 27,
Lordship, yes. Today, tomorrow, I'll get that.
or even tomorrow, we don't know what will be the position tomorrow.
Or day after is a holiday.
We have 4 days.
Monday, Lordship will take it up on Monday.
Tuesday.
Oh,
Let's
Tuesday.
to judgment of this honorable court, Lordship.
We'll go through, Mr. Cook, on
Lordship.
that day.
This issue has already been decided by this honorable court, Lordship.
We'll consider on that. Don't-
Lordship.
Okay. We're keeping it, read it and.
Lordship, on Tuesday.
All right, Lordship.
There are some amendment of rules in the act. Go through.
Yes, yes. I remember it is 6,000 a vehicle, maximum.
Here this, we do not have, but since you are saying 6.
That I'll find out. Tuesday, I'll place it.
All right, Lordship.
Prepare the computer.
Please, your lordship. Lord, if your lordship is pleased to peruse the last order, that is order dated 5/8/2024, my lord. On that occasion, my lord, one counsel appeared and he was supposed to file the Kalatnama because I submitted that, my lord. I have already written the brief, my lord. But his name is not recorded in the cause list, my lord. And I also have checked out the record that no Kalatnama has been filed. So may I pray one thing, my lord? I may have it for 1 week time, my lord. I have to take instruction from the client whether he is like to argue the matter through this new set of counsel.
On some Sofiqul Islam appeal.
Yes, my lord. But his name is not there in the cause list also, and he has.
Because he did not file Okalat now.
Yes, my lord. So may I have 1 week time, my lord? On that occasion, my lord, if nobody appears, then I'll argue, my lord. Because I have to take instruction. Otherwise, the
Obtain instruction because somebody else has appeared on his behalf.
Of course,
right?
my lord.
So obtain the instruction and tell us when.
Yes, my lord.
When.
Next week on any date, my lord.
Next week.
On any date as per the convenience of this honorable court.
31st.
Lordship, Lordship, I'll submit a objection. Kindly to.
No, you have time till 31st.
Obliged.
We have to continue.
May it please the Lordship. Lordship, some criminal revision filed by CBI Lordship against the order and judgment passed by Juvenile Justice Board.
Yes.
LCR has been received by this court, Lordship. Fact is that, Lordship, pursuant to a letter, Lordship, some people has taken admission in medical college, Lordship, in AMC, Assam Medical College, and accordingly CBI was entrusted to investigate the case. And Lordship, CBI submitted 11 charge sheets, out of which 1 charge sheet is this, Lordship. And in this charge sheet, 2 persons were named accused, Lordship. One of the accused is a juvenile, and therefore it has been referred to the Juvenile Justice Board for conducting an inquiry. And after conducting the inquiry, Lordship, the board found the accused to be innocent, and therefore he was acquitted, Lordship. So the copy of the case 46, Lordship, is the judgment. Also, the error in the judgment is that, Lordship, according to us, Lordship, during inquiry, Lordship, CBI, Lordship, proved certain documents which were forged, Lordship. Those documents, Lordship, was proved.
Say 46.
46 is the judgment. It's 53, page number 53, the judgment starts from page number 53.
Page number 53. 53 is the judgment. 53 is the judgment. 46 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 is the jud
The finding of the board is that, Lordship, the CBI during inquiry, Lordship, has adduced evidence, 16 witnesses were examined, and Lordship, certain documents were proved. Those documents were not proved in original, Lordship. Photocopy of the document, as because trial is going parallelly against two accused persons. Therefore, Lordship, CBI during trial, Lordship, they used a photocopy of the document and it was stamped as proved in original, Lordship, though it was not compared. Therefore, on that, Lordship, the court below, Juvenile Justice Board has acquitted this.
Kindly show us the case 46, you say?
Page, Lordship, page 18 of the judgment, Lordship.
Page
The internal
18.
page 18 of the judgment, Lordship.
1-8.
1-8. Para, Lordship. 34, Lordship. The case record reveals the fight order dated 11/6/10. This board allowed the prayer of the prosecution call for the original case record dated so from the Court of Special Judicial Magistrate. However, the case record reveals that the original case record of the case was not received by this board, and the inquiry proceeds accordingly in absence of the record. So this is the finding, Lordship. Though there was an order from the board, the original record was never received by the board. And on the basis of the photocopy of the document, Lordship, the inquiry proceeds, Lordship. And therefore, those documents were not taken.
What
as
is the finding
finding, Lordship?
in that regard?
Page 23, Lordship, again. Page 23. There are 44, Lordship. PWD states that they have not produced the relevant CD from which Exhibit 4 was taken out. If the CD would have been produced and marked, the same would have been the primary evidence. But the prosecution, instead of producing the CD, produced the printout of the list taken out from the CD, trying to adduce as a secondary evidence. However, there is no clarification made by PW2 or any other person as provided by the law, thus failing to fulfill the requirement section 65B of the Indian Evidence Act. Therefore, Exhibit 4 remains as not proved. Again, Lordship, para 45, PW10 marked the roll number wise merit list and waiting list prepared by CBSE as Exhibit 47. PW10 also marked his signature in Exhibit 47 as Exhibit 47-1. PW in his examination deposed that he put his signature in Exhibit 47 today, attesting the content of the data from computer. In the cross, PW stated that he's put his signature in Exhibit, which is a photocopy. Finally, Lordship.
Who obstructed you to place the original records?
Lordship, we have filed the application before the Juvenile Justice Board. Only order was passed, Lordship. But the record, they have not sent the record. And witnesses are coming, Lordship, as summoned by the prosecution, Lordship. Therefore, we have no way out to examine the witnesses with that.
What is your application?
Or application we have not attached, Lordship.
But
It
you
is
have to make
evident
it a mention from para 12.
It is evident, Lordship, from the statement, I mean to say the finding of this court, Lordship. As I have already mentioned, Lordship, there is an order. Para 34 is the para 34. Para 34, Lordship, they kindly looked into. The case record reveals the white order that is on this board, allowing the prayer of the prosecution call for the original case record. So we have filed on the basis of our application, Lordship, our prayer was allowed. But the court below, Lordship, I mean to say the special magistrate, where the parallel trial of other accused person was going on, they have not sent the original record. Lordship, para 34, 35, and 36, Lordship. There is no fault on the part of the prosecution, Lordship. We have reduced the evidence with utmost care, Lordship. We have filed a petition, Lordship, for calling the record, Lordship. Order was there. In spite of that, Lordship, he was acquitted. The name of the accused petitioner was never in the merit list, neither in the waiting list. Nowhere his name was there at the time of admission in the medical college. Lordship. So with the help of this forged document, Lordship, he got admitted in the Assam Medical College, Lordship. That is the admitted fact, Lordship.
Barua. Look.
Letter dated 8/9/2003 was forged, Lordship. It was exhibited by the prosecution, Lordship, as Exhibit 10. And the merit is Exhibit 4, Lordship. The content of this two letter.
Now, Mr. Halloy, what do you want to say? First of all, the record was called for, it did not proceed.
Lordship.
Was it the fault of the CCL? Is it the fault of the CCL?
Definitely, Lordship.
Why?
Lordship, because
How the CCL will be there?
CCI, actually it is a fault of the court below, Lordship. Because a step has to be taken by the office of the CCI. Prosecution, Lordship, we have filed a petition, Lordship, as required. We have filed
We are
it.
talking about the child constitutional law who got the admission in the medical
Yes.
college, right?
Yes.
Now, the tribunal, the board found that the record, in spite of it was called for, it was not forwarded. The board found that the record was divided into two parts because one of the accused was a juvenile.
Yes.
Which was considered by the board.
Yes.
And now when the magistrate court forwarded a record, it was not signed as because made a photostat copy of the original record and forwarded to the JB.
Lordship.
Now in the because when it was forwarded to the juvenile board, it was not attested by this.
Yeah, it was not compared. It was not
on that basis. How will you prove? It was also not
Even
your
if
priority
assume-
relevant point of time
Lordship.
to prove those documents.
Even if we assume
To bring by special messenger those records before the board to prove it from original.
Lordship.
So it is your mistake.
Lordship, no, Lordship, it cannot
Why?
be said as a Lordship.
Because it is the prosecution who was supposed to prove from the original document.
Lordship, we have
It is the prosecution who issued the original document. And in the original document was not issued in the name of the CCL,
Lordship.
right? So when it was not issued in the name of the CCL, necessarily it could have produced it from the record.
For
At least
record,
by special messenger, they could have brought the records, he could have approached the tribunal.
no,
You have called for the record.
Yes.
You didn't receive.
Lordship.
You could have made separate application.
Lordship, we have made the application.
Why you have only given the photocopy?
Lordship, we have made the application.
You have
And
made the
accordingly, order
application,
was
but
passed.
in spite of that, the record did not receive because matter was also pending before the magistrate court.
Right, Lordship.
And the accordingly proceeded.
Proceed.
At the relevant point of time, the prosecution could have proved
So we have,
bringing it a record by a special messenger.
Lordship, they will not give, Lordship.
Who will not?
Because court below, because it's an official procedure, Lordship. It's an official procedure, they will not give us, Lordship. Once a order was passed, it has to be intimated by the court below through its procedure. And Lordship, the court below, when send the requisition, Lordship, the special court would have sent their employee, Lordship, to send the record, Lordship.
Did you make any prayer?
But this is evident from the statement, I mean to say the paragraph 34 that we have made an application, order
At
was
the
there,
relevant point of time, when this document was to be proved,
Lordship. Prior to that, Lordship, we have filed the application and order was passed.
see, Mr. Harlowe, it was found that record was not made available before the board.
No.
The board proceeded with the matter. Right?
Right.
At the relevant point of time, when this particular 2-3 documents was required to be proved, did you make any prayer before the board?
That is not within my knowledge, whether because
Holloway, now after the order has been passed, you have. It
Even
was
if it-
required if, because the board have recorded everything. Even the signature of the concerned person from the CBSE was recorded on that day. His signature was taken on that particular photostat document on that day.
right, Lordship.
So
But even if we assume,
that's why the board found that it was a mistake on the part of the prosecution. Where is that illegality, Mr.?
Lordship, even if we assume that these documents are photocopy, should be treated as a secondary evidence, Lordship. To be treated and that apart,
Duty
Lordship,
to prove.
Lordship, that apart,
Whose duty to prove?
Lordship, we have proved it.
How? By paying a photocopy.
Photocopy of the evidence along with the witnesses, Lordship, who has prepared those documents, Lordship. He proved the signature that it is not his signature. The letter which was forged, Lordship.
Where is that? Where is that finding
Letter, Lordship,
in the judgment?
Lordship, page number 29, para 53, 53, Lordship. '53 of the judgment, Lordship. Para 53, page number 29.
Yes.
In the above para, it is already held that exhibit 4 is not a secondary evidence, and the genuineness of exhibit 4 is also disputed. When the documents produced is itself in question, oral admission as to the contents of the document are not relevant. Thus, it appears the PW3 did not bring forward any proof materials fact regarding point number 1 and 2. The PW3 is the person, Lordship, who has proved that document, Lordship. But the statement, the oral evidence of PW3 was never taken into consideration, Lordship. That apart, there is scientific expert report, Lordship, which was exhibited as exhibit 54, Lordship, GQD report. The GQD report also says that the signature of the person who has made his signature in exhibit 3 was not his signature, Lordship. PW5, Lordship, again in paragraph 54, PW5 stated in her evidence, the entire process of examination and allotment sits to the candidates in the medical exam. However, in the cross examination, she stated that she did not depose the detailed procedure of admission before CBI. Further, upon going through the case diary, it reflects that such procedure was not stated by PW5 in a statement recorded on 161 CRP. PW5 stated that at the time of giving admission to the candidate under 15% of all India quota, they have to see the rank card issued by the DGHS, allotment letter issued by DGHS, education certificate and CBSE marks. PW5 added that those candidates who have not produced the required document are admitted provisionally, giving an undertaking to submit the same in the first year. PW5 stated that as A1 could not produce the required document, he was admitted provisionally. PW5 further stated that within the time frame of A1 did not provide the required document, and then she informed the matter to the. So, Lordship, PW5 statement of other oral evidences are also there, Lordship, that he he was admitted provisionally, Lordship. His name was not in the merit list, neither his name appears in the waiting list, Lordship. But those facts were never taken into consideration, and only on the
Read from para 41. The judgment.
May I read, Lord? However, in the absence of any documentary evidence on record to prove the allegation beyond all reasonable doubt made against accused one, the oral evidence lying in the record are to be appreciated.
Or read from 40.
40.
Or in better if you read from 30.
38, Lordship.
Come from 36.
May I read, Lord? The case record reveals the order dated 11/6/2010. This board allowing the para of the prosecution call for the original case record from the Court of Special Judicial Magistrate, Kamrup. However, the case record reveals that the original case record of the said case was not received by this board, and the inquiry proceeded accordingly in absence of such record. Paragraph 35. Hence, from the discussion made above, it can be concluded that the documents adduced by the prosecution does not come in view of secondary evidence as provided by the Indian Evidence Act. However, upon going through the said documents resting in the case record, it appears that all the documents are marked exhibited. Surprisingly, all the documents which are marked exhibited are written as proved in original. But as already discussed above, the original record was never received by this board, and thus there is no question of comparing the photocopies with the original and proving the same accordingly. It appears that on each and every date of prosecution evidence, the learned special PP was marking the same as proved in original without comparing the same with the original, and even though if marked the same as proved in original, failed to make his signature on it. Lordship, PP never signed, Lordship. There is one more mistake. Original is to be signed by the presiding officer, Lordship, after comparing, Lordship. Either by the presiding officer or by the comparing assistant, Lordship.
Go ahead.
Thus, it can be concluded the documents adduced by the prosecution and marked as proved in original are not the copies compared and proved with the original. As upon going through the said documents resting in the case record, it appears that all the documents are marked exhibited. Hence, the procedure regarding marking exhibiting of a document is to be gone through. A document to fulfill the criteria of becoming a documentary evidence must go through the following 3 stages. Production at the initial stage, that is at the time of final form preferably. Admission, exhibition in the trial stage, that is tendering, producing the time of evidence. Proving at the final stage, judgment. Para 38, mere production, producing a document or marking of a document as exhibit does not make a document proof. Though the documents were lying in the case record and was marked as proved in origin, which it was not as discussed above, and then marked as exhibit, it cannot be exempted of proving the same as per Indian Evidence Act. The documents relied upon by the prosecution were submitted by the IO along with this charge. The said document in photocopies were admitted as evidence and marked as exhibits, and thereafter formed a part of the record. However, in regard to the last stage, the proving of the same, the said document ought to have been compared with the provision of the Indian Evidence Act. However, in the above paragraph, it is already held that the documents adduced by the prosecution does not come in view of the secondary evidence as provided by the Indian Evidence Act. And further, the documents adduced by the prosecution and marked as proved in original are not the copies compared and proved with the original. Thus, it can be concluded that the said documents adduced by the prosecution are not proved as per law. Therefore, from the above discussion, this board comes to the conclusion that documents, except Exhibit 1, does not forms the documentary evidence of the case and are not proved as per law. Further, as these documents are not taken and proved in accordance with law, hence these documents are failed to draw the presumption as provided under Section 80 of the Indian Civil. This same principle also applies to Exhibit A and Exhibit B, which are adduced by the defense side. However, in absence of documentary evidence on record to prove the allegation beyond all reasonable doubt made against anyone, the oral evidence lying in the record are to be appreciated. However, the prosecution evidence reveals that mostly all the prosecution witnesses relied upon some of the other documents to give their oral evidence. Section 59 of the Indian evidence is agreed as follows. All facts except the contents of the documents of electronic may be proved by oral evidence. Hence, the oral evidence of the record cannot prove the contents of the document in absence of the primary or secondary evidence itself adduced. Though the documents, except Exhibit 1, does not fulfill the criteria of documentary evidence and are not proved as per law, for the argument's sake, the said documents are referred while appreciating the oral evidence on record, as all the prosecution witnesses relied upon some of the other documents to give their respective oral evidence. PW2 marked the merit list, all India quota list of 2003 as Exhibit 4, containing 57 pages. Similar to the other document introduced by the prosecution, the same also appears to be the photocopy. PW2 deposed that Exhibit 4 is fed into the computer and the computer are locked with the password and the data is stored in CD form and the CD is submitted to MB cell. PW2 states that they have not produced the relevant CD. Section 65 of the Evidence Act reads as follows. Notwithstanding anything contained in this act, any information contained in electronic record, which is printed or a paper, stored, recorded or copied in optical or magnetic media produced by the computer, shall be deemed to be also a document, if the conditions mentioned in this section are satisfied in relation to the information of the computer in question and shall be admissible in any proceeding, without further proof or production of any original as evidence or any contents of the original or any facts stated therein of which direct evidence would be admissible. Section 2 of Section 65 of Indian Evidence Act provides that a detailed condition in referred to subsection 1. Para 44, PW2 state that they have not produced the relevant CD from which Exhibit 4 was taken out. If the said CD would have been produced and marked, the same would have to be primary evidence, but the prosecution instead produced the said CD, produced the printout of the list taken out from the CD, trying to adduce the secondary evidence. However, there is no certification made by PW2 or any other person is provided by law, thus failing to fulfill the requirement of Section 65B of the Indian Evidence Act. Therefore, Exhibit 4 remains as not true. Lordship, with regard to the certificate, Lordship, there are rulings which say the certificate is not mandatory, Lordship.
Go ahead.
Lordship. PW10 marked the roll number merit-wise list and waiting list prepared by CBSE as Exhibit 47. PW10 also marked the signature in Exhibit 47 as Exhibit 47.1 to Exhibit so-and-so. PW10 in his examination in chief deposed that he put his signature in Exhibit 47 today, attesting the contents of the data from computer. In this process, PW10 stated that he put his signature in Exhibit 47, which are in photocopies. Exhibit 47 and were produced in photocopies. However, it is already discussed and held accordingly that the documents adduced by the prosecution, including Exhibit 47, is not marked and proved in accordance with the provision of secondary evidence as provided under the Indian Evidence Act. Further, PW10 said that he put his signature in evidence Exhibit 47 today, attesting the contents of the data from computer. Firstly, the said attestation by PW is not sufficient to satisfy requirement 65B of the Indian Evidence. Secondly, the order dated 30/9/2011 does not reflect any order of the board, wherever the board permits PW10 to put his signature in Exhibit 47. Once a document is enclosed and submitted, which the charge sheet, the said document becomes a part of the record. Therefore, said documents could not be edited, changed, marked without the permission of the board. However, the prosecution without the permission of the board got the signature of PW10 in Exhibit 47 and further also marked the same as Exhibit 47 to Exhibit so-and-so. The CBI, being a central authority, is expected to know the procedure for making, exhibiting a document during inquiry trial before the board. However, the learned special PV went to the extent of not only allowing his witness to sign in the document, which is a photocopy, but also allowing the witness to sign in the said documents without the information permission of the board. Hence, Exhibit 47 cannot be held as a proof document evidence for the purpose of appreciation of evidence. A1 was charged under section 470 IPC and 471 IPC along with section 120B, alleging that A1 cheated by using as genuine the allotment letter, which he knew or had reason to believe at the time of using it to be a forged document. Hence, to prove the charges against A1, primarily following 2 points are to be proved. Point 1, the said allotment was forged. Point 2, A1 used the said allotment letter as genuine, knowing to be forged. The prosecution to prove both the points brought 16 witnesses during the inquiry of this case. PW1 is the informant of this case, whereas PW 6, 7, 8, 11, 12, and were the seizure witness. The prosecution subjected PW 2, 3, 4, 5, 9, and 10, and PW 16 as other independent witnesses in the inquiry of this case. PW 13 was a forensic expert, whereas PW 2 investigating officer. PW 1 deposed that he received a letter from the Health Secretary, Government of Assam, dated 6/9/2006, and thereafter he made a complaint to CBI on 19/1/2007. PW1 also deposed that he forwarded the list of selected candidate members in the Medical College of Assam for the year 2003 by Exhibit 3:1 to 3:11. These said documents were under objection by A1 as they were photocopies and thus are already held to be not true in accordance with the Indian Evidence, as discussed above. PW1 said that he did not conduct any internal inquiry in regard to the allegation before filing the FIR. Thus, from the evidence of PW1, it appears that PW1 restricted his information to the extent that he received the communication from the Health Secretary, Government of Assam, and made the complaint to the CBI. The entire evidence of PW1 did not bring forward any materials fact regarding point number 1 and point number 2. PW2 deposed that his senior provided a candidate list and asked him to search, and when he searched the computer data in CD form, he did not find the name of PW1, A1. PW2 added that he took out the list of candidates at Exhibit 4. It is already held that above paragraph that Exhibit 4 stand as not true. Further, PW2 stated the said list was prepared and entered in computer by 1M4 and printout was signed by Sri S.R. Yadav. However, the prosecution preferred not to adduce the evidence of S4 or S.R. Yadav. Thus, it appears that PW2 did not bring forward any proof material facts regarding point number 1 and 2. PW3 in his evidence described that entire process of examination and allotment of seat to the candidate. However, in this question, PW3 stated that as he was not working the said post in the relevant year, hence he personally cannot say the procedure adopted for counseling and admission. PW3 deposed that through the computer generated records of counseling done in 2002 to 2005, and did not find the names mentioned in the list reserved for PP Burma. PW3 added that Exhibit 4 is a merit list, waiting list of the MBBS BDS under 15% All India quota for 2003, and in Exhibit 4 merit list, merit number 2251 in the name of Sanjay Kumar Behera and not the name of A1 lots. Thus, it appears that the entire knowledge of PW was based on Exhibit 4, as he did not have any personal knowledge of the same, as he was not working the same point of time. However, it is already held that the above paragraph that Exhibit 4 stands not true. Section 22 of the Indian Evidence Act proof admission, oral admission as to content of document are relevant. Oral admission as to content of document are not relevant unless and until the party proposing to prove them shows that he is entitled to give secondary evidence of the contents of such document under the rules herein contained, or unless the genuineness of a document is in question. In the above paragraph, it is already held that Exhibit 4 is not secondary evidence and the genuineness of Exhibit 4 is also disputed. When the document produced is itself in question, oral admission as to the contents of the document are not relevant. Thus, it appears that PW3 did not bring forward any proof material fact regarding point number 1 and 2.
So remaining other witnesses are Caesar witness or nothing
Caesar
like that or
GKV is
whatever.
also
Their
there.
other witnesses are not relevant. These are witnesses are relevant.
Lordship,
They could not prove the document.
Lordship, one thing is correct, Lordship, that the original was not proved.
When the prosecution failed, now you want to open it up again by this manner? Is it possible? Mr. Holloway, tell us under which
Lordship-
provision of law?
Lordship, it's admittedly, Lordship, the original were not proved.
So
Now, whether those documents can be treated as secondary evidence. The contents of the document, whether it can be proved by way of secondary evidence, as because the
you
original.
have read everything. Thereafter you tell us whether it can be considered.
Or it can be treated as a secondary evidence because
On
the
what
original.
basis?
Lordship, as because the
Because a photocopy can be considered.
Lordship may kindly have a look in the evidence act para 60, section.
If that is a photocopy can be considered, what will happen in the foreigners tribunal? If we have to accept your submission. Mr. Holloway,
Lordship, secondary evidence, Lordship,
tell us.
section 65 of the evidence act clearly says, Lordship, what are the documents which can be treated as secondary evidence, Lordship?
Yes, please tell us. Tell us.
Section, may I read section 64, Lordship?
Yes, kindly read.
Documents must be proved by primary evidence except in case wherein mentioned, herein after mentioned. Cases in which secondary evidence relating to document may be given. Secondary evidence may be given of a existing condition or contents of a document in the following cases. When the Lordship, when the original is shown or appears to be in the possession of or power of a person against whom the document is sought to be proved or near the document out of reach of. Lordship may kindly see 65C. When the original has been destroyed, Lordship not destroyed. B, when the existent condition or contents of the original have been proved to be admitted in writing by the person against whom it is proved or by his representative in interest. Lordship, this section will hit, Lordship.
Then how it was proved if you are reading
It was proved in the court, Lordship.
how?
By the maker of the document. It has not been made by the PW1, Lordship, who is the maker of the letter.
Who proved that document? In what procedure?
Lordship, it was proved in
Which
the
witness?
Lordship, PW1, PW3, all are.
As
all
how? Just read again how PW1 proved it.
PW1 has stated the letter. He has not prepared that letter. It is not his signature. And which has been corroborated by the evidence of the GQD, Lordship. The GQD report also speaks about the same, Lordship, that it is not the signature of PW1.
Report found that it was incorporated in the data by someone else. And finally it was by another person, right? But the prosecution did not prove that particular gentleman as well as that lady who incorporated in the data when who took out the printout, that one Madam Code.
Lordship,
The
they are not the-
prosecution but did not bother to produce them because the person who has signed it, he was not before the tribunal.
Lordship, admittedly, Lordship, he took admission in medical
See,
college.
your entire claim is that his name was not there.
His name was not.
Somebody else's name was there.
Yes,
And he under the Indian that quota he has come.
Lordship.
But how you have proved that? Because that document needs to be proved. You are saying the secondary evidence.
Lordship, merit list, which is taken from the
See, that
computer.
list. How you have proved that list? That
It
is
was-
the issue. How you have proved that list?
Lordship.
Hmm?
It was fetched in the computer. Even the CD, if you could have produced the finding of the code below,
See,
is that CD is
basically,
required.
we are talking-
CD is also a secondary evidence, Lordship. Compact disk, that is also secondary evidence, Lordship. Because
we
the
have
original
proved-
is the computer,
Mr.
Lordship.
Aloi,
The hard
just
disk ought to have
simple
been
thing.
called.
Entire issue is how you have proved that document.
Lordship, we have proved the document in the board, Lordship, by way of secondary evidence, Lordship. Your Lordship may kindly see the evidence of PW3. He has stated that, yes, this is the list, merit list, Lordship. This is the merit list, and the name of this person, accused person, was not there in the merit list. And this merit list has been taken out, print out of the merit list and taken out from the CD. Finding of the board that CD is required. Even if we produce the CD, that CD would be also a secondary
Where is the
evidence.
evidence of PW one? Which paragraph?
Lordship, I do not have the statement of witnesses with me, Lordship.
Always a half-baked CBI. Why? Why is half-baked CBI?
Lordship,
Tell us, Mr. Haloy, don't laugh at.
Lordship,
This is nothing to be amused.
Lordship,
Everywhere. Why? How many cases CBI have proved? There is a report. Nothing to be amused here. No. Come before court.
Lordship.
There is a proverb in Assam, Thalnai, Torolai, Nidhiram Sordar.
Lordship.
And CBI is like that.
Lordship, some copies are there, Lordship. PW1 copy, Lordship, I got it, Lordship. PW1, Lordship. PW1, may I read, Lordship?
Just a minute. We'll come back at 2 and verify. Borua, record need you.
Next.
Okay, may I read the evidence of PW?
Please wait for a few minutes.
No.
Mr. Hallo, which is that document?
Lordship, there is one more confusion.
Which
Lordship.
that
Two
has not
documents,
been
it was,
proved.
Lordship, two documents, Lordship. There is one more confusion after going to the evidence, Lordship. Exhibit 10, as per PW4, Lordship. It is the depth force document.
Which is that document?
Exhibit 10. Exhibit 10 is the letter by which you were appointed.
Letter by which what appointed?
These two accused were appointed in AMC.
Which are those two accused?
The Lordship, one is this present petitioner,
Yes.
and the another one is Lordship, Aviral Vatsa. Aviral Vatsa.
What was his roll number?
Is
What was his roll number?
roll number merit list mentioned as 2251.
One is Rahul Kumar. Who is the other one?
Aviral Vatsa, WATSA, Vatsa. Both of them.
Total how many candidates?
9 candidates. Lordship. Total in this by this letter, which was for 2 candidates, these 2 candidates. Lordship.
How many were?
Investigation for 9 accused. Suspected accused, Lordship.
Total 9.
9, Lordship.
Before filing this appeal or this petition, have you checked the records? Mr.
Records,
Haloi?
Lordship, I have come today, it has been placed before your Lordship, and they are not willing to give because it was before your Lordship. So prior to that, I have not checked.
Whether the CBI Prosecutor,
Lordship.
verified these records because something else we could see here now. The reason is a list was forwarded, a list was placed consisting of names of 15 candidates for the second round of consultation here for the Assam Medical College under 15% quota. And those documents were accepted by the board. In the list of those 15 candidates, name of the respondent was not there. And those documents were accepted by the board. That's what I'm saying.
Okay.
Have you ever verified?
Lordship, those documents are not with me, Lordship. The CBI has
Before filing, because the matter was available before the principal board at Dibrugarh, you did not choose to look into all these records. Under 15% quota, how many candidates were allotted in the Assam Medical College, Dibrugarh?
those facts are not with me, Lordship.
Why you are having only see, this is Mr. Haloi, this kind of things cannot be accepted. You should know how many candidates under the 15% quota has been given in the Assam Medical College. Without having all these informations, how come you are filing this appeal?
I am confined to the judgment, Lordship. And the statement.
Some facts you must be always aware of. All persons were admitted in the year 2003 in the Assam Medical College under the All India quota. All are not illegal. You had suspected 9. So
9.
total how many? That's what you want to know from you. Whether intentionally or the CBI is not providing you these information. What is the reason?
Lordship, I don't know, Lordship. I'll have to then take instruction.
What instruction, Mr. Haloi? Then why you have argued? If you do not have all these informations with you. And these facts should be in your fingertips. You are the counsel. Nobody will fetch you. You have to acquire it. Some things cannot be fed to the council. The council has to take out all these materials from the client. But no. This kind of half-baked submissions is not acceptable, Mr. Haloi. Mind it, you are representing CBI, not anybody. We're adjudicating some important issues. On repair of Mr. Haloi, counsel for the petitioner. Release this after 3 weeks on a date to be fixed by the registry. Record declared to review. Yes.
Yes, may it please, Lordship. Lordship, Kindly see page 23, Lordship. Lordship, today I will argue not only on merit, Lordship. I am on quantum, Lordship. Also, 8,000, Lordship, it's too high, Lordship. So kindly make it, Lordship, 3,000, Lordship. He is unemployed, Lordship. Wait to hear. Enough on the information clear. Take your seats.
16:45, 4:45, 4:50 পড়ো। ঠিক আছে, 16 মিটিং আছে। Ms. Jahan, you are entrusting to some more work.
Lordship.
Now, see, this is a particular direction given by the SDJ for payment of maintenance.
Huh. Hmm.
To the respondent at 8,000 per month
20,000,
under 125.
125, yes.
Now, see, this order was passed on 29th of November 2021.
28th of November, no, this order is, yes.
29th of November 2021.
Huh.
If you come to page number 23, you'll know.
Hmm.
And what we have seen that in terms of the directions issued by the Honorable Apex Court in the case of Rajneesh, the affidavit of disclosure of assets and liabilities was not there before the magistrate. And that direction of the Honorable Apex Court was issued on sometimes in November, I think so, 2020.
Rajneesh was 2020. Acha.
4th of November 2020.
Acha. I thought 22. This is the
And,
first after that.
After that, and should have complied with that direction. So you just go through the specific provisions of Rajneesh, by which has become a mandatory direction for all the magistrates or family courts or appellate court to consider that aspect, that before giving any maintenance, there has to be that kind of affidavit of assets and liabilities of the party. So verify it and tell us on Tuesday. So
And if it is not done, what will be the outcome?
we'll send back the matter to the family court
Yes.
for redetermination. And we'll see if in the meanwhile some amount has been paid or not. If it is paid, then we'll ask them to continue to pay or reduce the amount to certain extent and continue to pay. That will be our concept. The thing is this, find out going to the residence because there are certain provisions made in it. And it is specifically because in that particular judgment, it has been clarified that all matters pending either before family court, magistrate court, or appellate court
Yes,
have to follow this.
they have to follow this.
Go through it and let us know Tuesday. We'll fix this on.
Acha.
We go through that judgment and
Yes, yes.
particularly the issues. Because the
issues
assets and
and
liabilities
everything.
has to be filed through an affidavit because the Apex Code has made 3 annexes. That 3 annexes has to be complied with. But we have seen many of such orders where the magistrate court or the appellate court or the family court have considered that aspect of the matter. Orders passed after since from 2021. But these are the matters where we have seen in some cases the magistrates did not comply with all the family court.
Many cases we have seen, Lordship has seen.
Complied with and some cases not complied. So wherever not complied, we will send back, right?
For any such judgment where it was sent back on non-compliance of
It
this.
is not there, but we'll send it back because that's the mandate of the law. It has to be complied with, right?
We can get some High Court judgment also.
If you see, go through it, and but we'll take it up on Tuesday. Go
Lordship.
through the Rajneesh judgment and particularly that direction is there. Right up.
Lordship. Obliged.
In fact, pursuant to the direction of the Honorable Apex Court, our registry in the judicial side,
They must have also issued some notification.
they have circulated to all the courts on 18th of November 2020. Disposed of on 4th of November, our High Court have circulated to all the 4 states all the family courts, all the sessions court and all the magistrates on 18th of November.
18th of November 20.
I have the documents for us, so that we have called for it.
So many
So-
months after that.
But the judgment doesn't disclose anything that it was followed. That's why. We'll have it on Tuesday.
No.
You make a mention in the morning about this matter, because there will be other matters of. Yes.
May I please, Lordship? Lordship, as per order of the 1st of August, Lordship, we have filed an affidavit, Lordship, affidavit in opposition.
Maintenance, huh? The other party is not here. So I said.
Yes, madam, you are there.
Lordship.
This order was passed when?
The maintenance order was passed on September 2023, Lordship. Final order, Lordship. And there was interim order also, Lordship, which was passed.
The direction issued by the Honorable Supreme Court in the case of Rajneesh was followed in this matter while determining the compensation, while determining the maintenance.
Lordship, that. Twenty-three.
The judgment doesn't reflect.
Lordship, the order doesn't reflect so, Lordship.
So when is a specific direction while determining compensation in any other
Lordship.
domestic violence act?
Lordship remanded back, Lordship, to consider on this aspect, Lordship.
Okay.
But
so
till then, Lordship, the interim, yes, Lordship,
Tuesday.
Lordship. But
Zahan, go through para 62 to 72 of that judgment and 129 paragraph SCC. Original judgment will be different.
there are 120.
2021 to SCC 324.
That I have. When I've gone through once, not 62
272
and again 100 and
and 129.
I'll go to the entire. Document.
No, because that was the direction issued by the Honorable Apex Court.
But here, one thing, Lordship, he himself produced the salary certificate, Lordship. Salary certificate was produced, Lordship.
That was produced, but
Before Rajneesh Neha, that was the procedure that was followed. That was-
But this is judgment of September 26th of September 2020.
Yes. Yes, Lord. Oblige, Your Lord.
Obliged, Lordship.
that it is an appeal against conviction.
Along with the previous. Can you explain about?
Convicted under section 304 for 8 years.
Arlene Katkote. Or Mr. Counsel appearing for the appellant. And Mr. B. Sharma, learned additional public prosecutor. Appearing for the state respondent number 1. Agree with the judgment and order dated 06/06/2024 passed by learned Session Judge Borpeta in Sessions case number 376/2015. Reference to GR case number 2531/2013. Please take your seat. Arising out of Borpeta PS case number 1399 of 2013. Whereby he has been convicted under section 304, in bracket part 1, bracket close, public 447 of the IPC, and sentenced to undergo rigorous imprisonment for 8 years with fine of rupees 5,000 in default of payment of fine to undergo rigorous imprisonment for 2 years. Default of payment for 2 years. And with fine of ₹500. In default, the prime rigorous sentence for 1 month under section 447. Setting of the period of detention already undergone by him during investigation, inquiry and trial. The appellant preferred the statutory appeal. Appeal be admitted. Call for the records from the Court of Learned Session Judge. Call for the records of Sessions case number 376/2001. In the Court of Learned Session Judge Forfeited. Decided on Friday, 06/06/2020. As Mr. P. Sharma, learned additional public prosecutor, has accepted. As appeared on behalf of the state respondent above, no comment notice. The appellant shall serve requisite extra copy of this memo by Mr. Sharma on or before 27/08. Appellant shall take steps for subsequent notice on the respondent number 2. Inform to the registered post secretary, providing his correct and proper address of the on or before 28. Detail 28. The appellant shall also take steps on the respondent number 2. To the usual process, I enter district magistrate format. In his proper address. List after 6 weeks, candidate to be fixed by the weeks. You are in the custody?
My IMA considered.
I had to click it. By an order passed today. Connected criminal appeal number 206/2024. The appeal preferred by the applicant against the judgment and order of conviction. Dated 06/06/2024. Passed by Learned Session Judge Borpeta in session case number 376/2015. Has been admitted. And the records of the said sessions case has been called for. This application of the petitioner shall be considered for after receipt of the relevant records from the trial.
Okay.
The dispute between the husband and wife, my lord.
We are still waiting. There is no possibility for the.
Yes, my lord. Proposal was sent.
Failed.
He is stating that he has not paid the area allowance also,
Area allowance.
area. But at least some amount is there, then
What about
I
after
will
the
agree,
final order? This is
1
against the final order.
final order,
What about, it has not been stayed.
not state,
Have you paid any
Yes,
amount?
68, page 68.
How much you have paid? Are you paying regularly or not?
Yes,
No,
my lord.
as per my
5,000 per
instruction,
month, my lord, he is regularly paying.
and there
So
is
as,
But area,
area
so was
also.
that you are paying 5,000.
Left in last order, my lord, in case 60, my lord. In both the cases, my lord, 5,000 per month he is paying, my lord.
Where is that?
My lord, to page 60, my lord.
60.
60, my lord.
No.
It is the
After this order. After this order, are you paying or not?
Yes, my lord.
Show us that you have paid. Where is that form? There will be an order from the.
No, after the order dated, my lord, 18/4, my lord, the petitioner, my lord, has not paid, my lord.
So why should you admit this?
There is a possibility, my lord.
Why should you admit this? Why should you hear your prayer?
5,000 per month, my lord, he is paying.
Show us that you are paying after this order,
That document I don't.
then Mr. Patgir is
As
correct,
per-
you are
as
not
per
paying
instruction,
anything.
My lord, he is paying. my lord.
Since August 2019. When did you pay?
In every month, my lord, he is paying 5,000, my lord. So far, my,
You are.
my lord, my lord. But document is not with me, my lord.
Then how can you consider your submission?
Kindly, my lord, see,
Why
my
should
lord,
we admit this appeal first of all? Tell us, if you're not paying anything.
In last, my lord, in
See, first of all, tell us why should we accept it when you are not paying?
so far, my instruction, my lord, he is paying, my lord. But document is not with me, my lord.
Then we'll make an order. Counsel for the petitioner is submitting his paying that he should produce the record that he's been depositing every month. Will that do?
So far, my instruction, my lord.
See, you are not appearing in one particular case. You are appearing in many cases, right?
Yes,
The council.
Yes.
The trust between the court and the bench is very important
Yes.
because the court always believes the submission of the bench, court, the lawyers basically. So make your statement knowing fully well which is correct or not.
I have also stated in my paragraph.
Unless you have that kind of anything before
Yes,
you,
my lord.
don't make such statements.
So,
This is very important.
yes.
Once the trust goes forever. Very difficult to getting in back.
That will be harmful for me also, my lord.
So that's why I'm telling you. What is the proof that he has been paying regularly? Do you have anything to say on that?
Next date, my lord, I
Will not give you date.
I'll
Will not give you date.
will be record, my lord.
Mr. Patgir is correct. He has the instruction that you have not paid.
Oh, my lord.
Since when he is not paying?
my lord, I have, he's not confirmed, but, areas amount is.
You are
not,
asking
there
for
is a
areas.
direct-
Are you getting regularly or not?
my lord, in my lord, maintenance case, he paid, my lord, 2,000 per month, my lord. And share case, my lord, instead case, my lord, he has not paid as per my instruction, my lord. 3,000 per month.
Both the petitioner as well as the respondent. Number 2. On the next date fixed, shall apprise the court as to the amount of maintenance paid by the petitioner to the said respondent after the final order dated 15/07/2022 passed by the Principal Judge Family Court, Barpeta. List on in abstract criminal meets case number 1862021.
By this, my lord, petition, my lord, challenge the, my lord, order, my lord, passed by the additional district judge, my lord. In DB case, my lord.
And the order is at 1804/2023 passed by the Learned Additional Session Judge FTC Barpeta in criminal appeal number 06/2023. List on 11th September.
Oblige.
And on 31st of August.
May I please your lordship? Lordship, there is an appeal against acquittal, lordship. A similar order was passed. There were 5 appeals disposed of in a common judgment. Already we have filed an appeal against one of the criminal appeal. This is the second appeal, lordship. The judgment is the common judgment.
Similar or appeal pending?
Lordship, yes. The order I have just now passed over.
This matter relates to 88.
Lordship, lordship, no, this, the current matter relates to
89.
87, lordship. The matter which the lordship is holding.
This matter relates to 87. What is your appeal?
Page number 2, Lordship, cost type. In appeal number 87 of 2008. The record will be the same.
Appeal আছে যে common order করবে খালি আছে এটা কথা লিখে দাও। Common judgment dated 29/05 in Again, judgment and order of acquittal dated 29/05/2024. Common judgment on the list passed by the Court of Additional Session Judge Appeal C number 3 from Metro Guwahati in appeal number 87/2019 along with 88, 89, 90 and 91 of 2019. Our order was same order will be there.
Lordship.
List along with criminal appeal number 245/2024. Total line number by order dated 12/08/2024. The court has already called for the records of the relevant criminal appeals, including the criminal appeal number 87.
But we will be taking steps, Lordship, that will be the same. Highly obliged.
Sure. Yeah, please, Your Lordship. Lordship, 482 application. In this case, my lord, a DB case was filed by the respondent number 2. And initially, ad interim 2,000 rupees was, my lord, directed to as maintenance. And the petitioner, my lord, was regular in payment, but that payment was handed over to his earlier, my lord, engaged counsel, and that counsel, due to his negligence, sometimes he pays to the respondent, and sometimes he.
Have you filed any, whether the petitioner here filed any complaint before the?
No, I have
counsel?
not filed any complaint,
Then,
but this fact I have narrated in this petition.
so you're bound to pay.
My lord.
You're bound to pay.
Yes, yes, I'm bound to pay, my lord. So in the meantime, my lord, that DB case was, my lord, got dismissal. Thereafter, against the dismissal order, petition respondent number 2 had filed appeal under section 29 of the DB Act before the, my lord, session court, and by the order dated, my lord, 27/7/23, the learned appellate court, my lord, overturned the dismissal order of the DB Act, main DB case, my
The
lord.
interim,
And
interim maintenance
no, my lord,
was finally disposed of.
yes, finally disposed of, and it was, my lord, directed to pay 5,000 per month from the date of the filing of the DB case, my lord. And this order was filed on 27/7/23. Thereafter, it gone to the execution, my lord, and by the execution court, distress warrant was issued on, my lord, on 9/10/23. Thereafter, 6/12/23, NBW was issued. So I am before this honorable court
for quashing of this, my lord, dispatch of warrant and NBWA. But my lord, in this case, I am straightway subject. Just a minute, just my lord. Dr. Gogoi,
Yes, Lordship, please.
we'll come to that. The first order was passed by
the.
JMFC
Yes.
on 17th of September 2022.
Yes, my lord.
Yes.
And the appellate court passed the order
Dated on
27/7/23.
27/7/20. Just tell us whether the judgment of Honorable Apex Court in the case of Rajneesh was followed, complied with.
Yes.
Yes, complied with.
Yes.
Judgment of the case decided by the Honorable Apex Court in the case of Rajneesh, complied with.
Monus, this honorable court has referenced the Bombay High Court. My contention is that, Your Lordship, that has
Mr.
not been
Gogoi,
mentioned.
we are asking only one thing, whether the judgment of Rajneesh was complied with or not by both the learned magistrate as well as the appellate court.
In fact, my lord, I just got it. The issue was raised in the Honorable Supreme Court and the Supreme Court had ordered for recirculation of the judgment to all the judges as well as.
It has been done. That's what we have pointed out on 18th of September 2020. We are keeping the records. Okay, do one thing. Both of you go through the judgments of the Honorable Apex Court in the case of Rajneesh. Note down the judgment 2021, 2 SCC 324. It was decided in November 2020, 6th of November.
Lordship.
Mr. Gogoi,
Lordship.
go through it and tell us.
Lordship, Lordship.
প্রণবে একটা order লেখ। Artin Paturi,
2000
list along with
21.
প্রণবে মারিছে। তাতে প্রণবটারে মরাইল। প্রণবে মারিছে। প্রণব দিবা file number. Mr. S. Das for the petitioner. Mr. B. Sharma, additional public prosecutor for the state respondent number 1. And Dr. B. N. Gogoi, learned counsel for the respondent. Agreed person. It will come over Tuesday.
Lordship. Deep level.
You are appearing for the respondent?
Yes, ma'am.
Where was the office note? Dated 19/08/2024. Issue reminder to the Lanet MFC Kamrup Metro Guwahati. For the relevant report, it was called for by order the 3107. List on 11th of September.
But till next date,
11. Getting the report, clarify everything. Yes, wait till 11th. We'll pass the order.
11 September.
so it's a case where the petitioners filed this petition for quashing of the FIR, Lordship. It was registered pursuant to the direction of this honorable court, Lordship.
No representation on behalf of the petitioner on call. The first of also, in the first of this petition was taken up for with the identification and the petitioner remained unrepresented. The previous occasion, I on 25/07/2024. From the record, order it is revealed that even the previous occasion on 25/07/2024, the petitioner remained unrepresented. We are going to live with no on to the council. Part Mr. M. Halil and standing counsel for the city. By order dated 12/09, 25/07/2024. It was already recorded that since 19/12/2019, the interim order passed earlier on 02/09/2019 observing that no coercive measure shall be initiated against the petitioner was not extended. This criminal petition relates to quashing of regular case being RC number C, capital C, 3 capital A 2019 SHG, comma, Police Station, CBI oblique ACB, Shillong. This cutting by the petitioner. This criminal petition by the petitioner for causing the regular case being number such and such. Registered A2 SHG oblique 2019. Registered under sections 120B oblique 420 IPC. Read section 13 in bracket 2 and 13 in bracket 2 in bracket small b. Apology. Crossing over 13(1)D. Page number 27. Page number 27. Mark. Initiated against the petitioner. Petition dismissed for not prosecuting. Adam manually लिखित होगा.
Olive.
Please, Your Lordship, I am for respondent number 2 and
Just a minute. You are appearing for whom?
for 2 and 9, Your Lordship, respondents 2 and 9. But Lordship, presently we do not have any contact with both the respondents, 2 and 9. So we do not have any instructions also. We have been unable to contact them also.
Here is the office note. There are 31/7/2024 and 19/08/2024. List on. Sixth of September. Registry cell apprised the court about the publication of notice to respondents in the two newspapers, the Assam Tribune, Green Bracket English, and Assamese Protein, Assamese. Okay. Along with the councils, along with the name of the council reflected in the cause list for the respondents. Registry shall also reflect the name of Mrs. MS, Mr. P. Sundi Vidil and Mrs. MS Sundi. As well as Mr. T. Talukar, Mr. Sundi. Nicolita. For the respondent, SSA Rahman. Mr. UK Borman. Mr. Mr. N. Anand. Mohammed H. Ali. Mr. A.K. Singh. For respondent number 1. And Mr. T. Talukdar. Mr. K. Saikya. Mr. J. Mahilari. And Mr. P. Chaudhary. For the respondent numbers 3, 4, 6, 7, and 9 in the cause list. The resistive cells apprise the report about the status of the SK Sohria, some judicial service, detailed judicial magistrate first class, Kuliabar. Sorry, লিখিছে নহয় who was judicial magistrate first class Kaliapur Nagaon. So, as on 08/06/2005. Petition.
There's an office note, it seems, perhaps.
Last it
Service.
was listed
Service.
2/8 lordship. And
You're
directed
supposed to take fresh steps, you have not taken. Why? Why have not taken?
So I will be allowed to not to take steps within 2 days.
Simple. A, B से भी ना हो.
এটা চেম্বাৰৰ টিবত কোন হয় ওই বেঞ্জামিন বেঞ্চুমণি দৈমাৰী মাতিব আৰু whereas the office note is at 19/8/2024. The appellant is directed to take first steps for service of notice on the response number 2 by registered post AD. The proper executive postal on all before 29th of August. List on 28th of September.
Online.
The line list failing with the court shall consider to
May I please, Your Honor?
as consequential order. Yes. Our concern superintendent. Concern superintendent. 445. Where is the office note dated 19/08/2024? 16/8/2024. And a Lozima court order dated 19/08. Petitioner is directed to take press steps for service of notice on the sole respondent by registered post with AD, providing its correct and proper address with requisite postal stamps on or before 29th of August. Petitioner is also allowed to take steps on the sole respondent by usual process to the district magistrate Kamrup Metro Guwahati. That step will be taken on that. Third, petitioner is also allowed to take steps as sole respondent by trustee of personnel service to be routed to the registry of this court. Such steps already in presence of one or more witnesses thereafter filed an affidavit for such. List on 28th of September. Failure on the part of the petitioner to take steps and sole respondent with the postal from the. Yes, we are appearing for whom, madam?
मेरे को चाहिए ये sorry.
Service, Lordship, we are directed to take steps upon Mukut Soikia in two address, separate address, we have taken steps. Lordship.
Have you filed your Wakalatnama?
Yes, Your Lordship.
When?
On 19th.
What's your good name?
Ma'am.
What is your
TM
good name?
TM Lahakar.
Heard Mr. M. Halloy, learned counsel appearing for the petitioner. Learned standing counsel CBA appearing for the petitioner. And I'm TM Law Court, learned counsel for the sole respondent. Service of notice. The sole respondent is complete. List this matter for
Admission.
On
Can it be on 6th of September?
6th of September. Mr. Das, you are appearing for the respondent? What's your good name, ma'am?
For the victim,
AK Choppy appearing on behalf of M. Biswal.
I is pending, in fact.
Right,
Records have
counsel for the
also come. 7 years incarceration under section 10.
And I'm not like the hundred editions of the particular stating to the state. Respondent number one. Also heard Mr. B.C. Das, Learned Council. 40. Respondent number two, informant. Ms. Jahan,
Judge,
any objection filed?
7 years not required unless it is 10 years.
No.
We will make order.
In custody since when? Yes, in custody since when?
Otherwise 22, December 22.
From the date of your judgment.
December 23rd of December. Perhaps he was inside during trial also.
From 9th of June to 2006, 9th of June 2016 to 12th of August 2016.
Acha. So 3 months period,
2 months.
2 months.
Lordship, may this matter come up for hearing, Lordship?
For hearing, we are not praying for bail.
He was.
We are not praying. Are you sure?
Lordship, my senior is on legs.
Your senior is on lake. Doesn't matter.
Otherwise, a statement is consistent before magistrate and the trial court. 6 to 7 years of small child. Accused to সৰু ল'ৰা নকৰে। Accused to সৰু ল'ৰাই নকৰে।
দেখুৱাই কিন্তু
Hearing
I know.
What?
I know.
I am here to the matter to hearing.
I know.
এখানে আইএ হিয়ারিং করলে আপনি গোটে তো করবেন Have you checked the record?
I'm not, the records I have not checked, but I have seen only 164 statement and her.
Yes, at that point of time, it appears that the two sisters and one sister-in-law
Ah.
and her friend was there at the place of occurrence.
But what her statement said that she went with her brother to purchase mosquito.
No, that is so thereafter it is, it appears that the accused took her to his house
To his house.
from the center.
Ah.
And at that point of time, as per the statement of the victim,
Hmm.
is that accused mother,
Hmm.
two
Acha.
sisters,
In the house.
one sister-in-law, and her friend
Oh.
was present in the house.
That is not there in the judgment as well. Acha.
That's in cross.
Hmm. Acha. No, he took her to his house. So
And in the
perhaps
house, it was occurred.
her
The
family
incident, it
members
was
will be
occurred in the
there.
house.
Ah.
You have to check out whether,
Contradiction or not?
no, not that. In the report of the police, IO's report.
Hmm.
How many rooms are there in the house?
That, of course.
There is no mention that it was in a room where
Hmm.
none was there. It is nothing in that kind of thing. But the presence of those people are there.
That will have to be said.
It's in vernacular. I don't think so. It will be not possible for you can go through it. Just a minute. That is why these case maths are very important.
Hmm. As far as the root of the case goes, I think that there is no contradiction as such. Presence of family members of যদি বেশি room to থাকিব
6 rooms in the house.
6 rooms. So,
Out of that, 3 are bedrooms. 5 bedrooms, 1 drawing room.
and section 10 only.
Possible.
Possible.
Number of rooms are more comparative. It's not that 2-room apartment or single room apartment.
And he is not a small boy. He is of 30 years of age.
30 years of
30 or so.
32.
32.
Case math shows that. Whether it was an evidence or not. Exhibit 4. So it was in evidence. But her statement again is that
161, of course, I could not read it properly.
just a minute.
And the brother has corroborated her statement.
No, because he informed after the incident, she started playing with that friend.
Huh. Mm-mm.
After the incident, she was playing with her friend in the house of the accuser. But while returning home,
She went to the cooperative market again to buy the nets along with her father.
first of all, she went there to buy that. That is the thing.
Medical doesn't support. Section 10, small girl.
Yeah.
It was a case of only rubbing, but there is no penetration. That's why their medical report will not come.
So the maximum punishment was given.
Maximum is 7.
Maximum to be given.
Maximum is 7.
Maximum permissible.
Ms. Jahan, even Mr. Das also, you are more acquainted. Read the 161 first, then you go for the 160. There are two things. Then you read the statement of the accused under 160. Mr. Das, you can also go through. Go through, you go, both of you go.
Statement of the victim.
Earlier, you were a judicial officer, you have adjudicated many cases, so you have nothing to say. You don't have to, just read it for yourself. You read it for yourself.
Yes, I've done treatment.
Ms. Jahan, you just go through. The statement of the victim.
Correct.
No, the second pink color. Only that much, only one sentence is there.
Only one sentence.
And you just, only that much.
Only that much. Rubbing.
Then nothing.
Nothing.
Then you come to 161 of the accused. No, 160 will come there, 164 later. Come to 161 of the accused. There is another writing.
No.
I think accused is there. No, not, I have not much. No, that is 160. You'll get it there. Accused is there. Got it, give it to me, I'll give it to you. Just. You have not marked. Dipon.
Even the source code.
Arun Das, Deepan Das, alias Arun.
Please reserve the statement. Got it?
Yes,
I'll show it to you.
yeah.
Give-
No,
give me the-
I'll get it.
It's there.
What up and differentiation, what up now?
Arun Das, oh, Deepan Das, yes.
Yes.
Yeah, or in the
Go to
second
them.
one. There is a-
No.
ঘুষুরিয়ায় মোর বিরুদ্ধে আনা সম্পূর্ণ অভিযোগ মিছা।
No, that's his statement. Just only for yourself, you go through.
Oh, yes, ma'am.
Congress.
Three.
Congress দলের সভানেত্রী।
Is the president of the Gaon Panchayat,
Gaon Panchayat.
the informant.
Hmm. Mother, no.
Anyway, now come to 164, the first pink page. There also, there is no such mention. Just read 164, Ms. Jahan.
But my lord, the one, yes, they are examining two defensive witnesses. Those two defensive witnesses have given a different version, my lord.
No, we are not on that because, any contradiction that what we are looking for.
The statement of the accused does not tell you with the.
No, you go through the 164.
Punch, right? Sure.
It is there.
মোৰ লগত বেয়া কাম কৰিছিল
There is no mention.
বেয়া
Only
কাম
one thing.
কৰিছিল
Bas that much.
মোৰ লগত 4-5 দিন আগত মোৰ লগত বেয়া কাম কৰি আৰু মোৰ পেন খুলি দিয়া কাম কৰিছিলে যোৱাকালি দিনৰ 11 বজাত দিনত মই সুস্মিতাৰ লগত মস্কিটো নেট কিনিবলৈ
No, there is nothing, only that much.
মা কিনিবলৈ যোৱা মাকে মই মাক কওঁ সুস্মিতাৰ মোৰ কি এইটো?
জহিনৰ আৰু শুভম আৰু পাছতে মোৰ কলম আৰু লাজতে আৰু কোৱা নাই মোৰ ক'বলগীয়া ইমানে
So this is only বেয়া কাম
And before police, that thing, whatever been stated in the
trial
during trial, as now come to the provision here, POCSO.
aggravated sexual assault
বুলি দেখিলে
final statement
whereas the offense of sexual assault was committed against the child.
Point for decision.
Contextual, simply after the question of the lady.
Read section 7. Section 5 won't come, section 6 won't come.
aggravated
Because 161, 164 doesn't say anything, whatever she stated before the trial court.
plus bear come and opening her
Those two.
clothes.
Even that part, because it in later stage, her statement was again recorded by the trial court. But in the 161 and 164, 161, whatever she has stated, same thing she has stated in 164 also. But she has stated something extra in the trial court.
161 is nothing, one sentence.
164, same thing.
Yes,
whatever is stated in 161, same thing has reiterated in 164. But added in trial court.
Yeah.
If that part goes,
But looking at her age, I mean, this, otherwise, something is done is there.
to,
But
thing is,
to what extent?
if it is sexual assault, it will become only.
Item number 45.
Mr. Alamgir, that is not appearing for the applicant. By this application, the applicant has paid for to 738.
Record may be called, but it may,
Your application to implead whom?
they are already, informer is died, but will expire. That's why his near relatives are also there. But I just
You
challenge
have
the provision.
mentioned the informant expired?
Expired.
Where? Where you have mentioned? Whose para?
It is also in judgment, Lordship, it is written. Yeah, yeah, not-
Which informant have expired? Mr. Alamgir?
Lordship, those filed the FIR, Lordship. He is,
Then who is the other respondent?
they are also included in this case also, they are the I.
See, you have want to make
They are
2 and
witness,
3.
witness, Lordship.
You want to make them party responsible.
Lordship. Question is that, Lordship, I just challenge the 319, Lordship, here.
But your limitation petition is pending.
Implement. Lordship,
So
question is that, Lordship, if LCR may be called for.
without admission, how we will not call for the record?
Lordship, actually, Lordship,
Why 2 and 3?
2 and 3, they are the, Lordship, the witness of this case. In the petition of time.
It is submitted by Mr. Alamgir that the informant of the case, Abdul Ali Mazumdar, expired. And his son and daughter, the Anwar Uddin Mazumdar, Muhammad Asarun Nisa, are the witnesses connected. Criminal case number 24 of X0. The applicant by this application for treatment of Sayyid Anwaruddin Mazumdar and Dr. 681 public 2024 referred by the applicant under section 5 of the application control the delay of 1 to with Mr. P. Sharma and additional prosecutor hearing for the opposite party of the yes. See, that said, Amaruddin Muttar and Mustafa legal error of the information. Muhammad Abdullah lately. That's hard and very hard. I agree. The applicant is not being son of Abdullah Muhammad Asar Nessa, daughter of late Abdullah or president of village Alai Part 3, Tillagaon, Tillagaon, post office, Alai, police station, but Mulai, yes, police station, party, opposite party numbers 2 and 3, slash respondent number 2. They connected. IA criminal 681. Next, IA 681. In view of the order passed today, the connected IA criminal 6738 the immediate party, opposite party numbers 2 and 3. To notice, registry still accordingly. Correct. As Mr. P. Sharma, an additional public prosecutor has not taken no formal notice to be issued for the department. Applicants shall take steps for the Mr. Notice of a newly immediate opposite parties such as I read the on or before 29th, providing their current and active for a list on 23rd of September. Right. That's it. By this, by the impugn order, the learned trial court acquitted the accused, both the accused, that is respondent number 2 and 3 of this application. Both the accused entered their counsel. So the appeal may be admitted and LC may be called for civil justice. NI case, reversible instrument, SEC bonds. But Mr. N.M. Hazarika, counsel appearing for the appellant. And Mr. S.J. Sharma, SAMAH. Current counsel, you are put 2 and 3.
2 and 3.
B. Sharma. Yes, Sharma. Also heard Mr. Rajesh Sharma, counsel appearing for the respondent. The appellant has filed its appeal statutory appeal. I agree with the judgment and order dated 21/09/2021. Part in CR case number 885C of 2016. By learned judicial magistrate first class commitment committee. Whereby the respondent numbers 2 and 3. The accused persons in his said complaint number 885C of 2016 were acquitted by the said magistrate. Admit this appeal. Call for the records of CR case number 885C of 2016 from the report of London Judicial Magistrate first class Kamrup Metro Guwahati. It was decided on 21/09/2021. Okay. As Mr. B. Sharma, no formal notice. The appellant shall serve requisite extra court. Appellant shall take steps for service of notice on the respondent numbers 2 and 3 by registered post provided that direct steps on or before 29/08/20. Just after 6 weeks. Same order. Earlier,
CR number is different.
case number 2. Same. 83. Full seal complaint. 20. Second case to tell liquor, please along with criminal appeal number 84. Okay, same order. No?
Obligation.
May I please, your Lordship? Lordship, from the office note dated 15/5/2023, it appears that LCR has been received from the trial court. And further, from the office note dated 16/7/2024, it appears that notice has been served. The office note states, Lordship, the service report against notice issued by usual court process through the office of the Judicial Magistrate Majuli on 1/4/2023 has been received with a signature of someone, Jayanta Hazarika. Jayanta Hazarika is the victim. He is the respondent number 2. And also with a vernacular note of the Jari Kora at the back of the return after service. And the same is tagged on record as flag SR in the supplementary file.
Heard Mr. E. Chaudhary, counsel appearing for the appellant. And Mr. B. Sharma, additional public prosecutor for the state respondent number 1. Peruse the office notes. That 15/5/2023, 16/7/2024, and 16/7/2024. We've seen that both by way of process serve as well as registered post notice have been served on the respondent number 2. Informant of the case.
Lordship is the victim.
The victim of the case. However, the said respondent has not yet entered appearance in the matter. Sufficient notice is complete. This appeal was already admitted for hearing by order the 21/03/2023. And from the office note to the 15/05/2023, it is seen that the registry has already received the relevant records. Moreover, the appellant is also been granted bail and the impugned order of sentence conviction passed by Planet Chetan Judge Malturi in Chetan's case number 74 with the date AM of 2021 has been suspended. The appellant has already been allowed to, has been already released on bail by order at the 21032023. Passed in IA with bracket criminal number 205 of 20. Place this matter for hearing in its.
Obligation.
May I please your lordship. Lordship, in this case, lordship, earlier occasion, lordship, custody was allowed, lordship. And accordingly, they served, lordship, and lordship, I may be allowed to, lordship, 1 day time to file affidavit in respect of custody. Lordship.
Where is the office number dated 17/05/2024? The appellant shall file affidavit towards completion of justice service on the response number 2. On or before 30. Yes, Mr. Sharma, are you filing any objection?
My lord, my lord, I will file my.
NES 306.
Yeah, ma'am.
In the meanwhile, registry has also received the records from the Planet Trial Court. The respondents state shall file its affidavit. Objection. In IA criminal 460/2023 on or before 2nd of September, list on 5th. I to I to
Obligation.
May it please your lordship. Lordship, as for office dated 12/8/2024, my lord, steps not received for respond number 2, your lordship. Lordship may be allowed to take fresh step for respond number 2, your lordship.
Pursuant to the order dated 21/07/2023. The appellant is allowed to take steps on the respond number 2 on or before 29/08/2024 by register posted providing is correct. Authority to take it for this purpose. List after 6 on a get to be fixed. The list is seeing that the registry have already received the records from the trial court records from the special judge corporate
deeply of the alert.
Just a minute, just.
May I please, your lordship? Lordship, as per office note,
Just, just. What? Yes, Mr. Sharma.
Yes, my lord.
The previous case, you have
Yes.
yet to go fight objection.
Yes, my lord.
Delicate. The state respondent shall file his objection. In. I. Number 2, correct. I'll go to that. Yes, ma'am.
My lord, date, my
Yes,
lord.
on or before. Same date.
My lord. 2nd of
On or before
September.
2nd of September, list
Ma'am.
on. Same date, according to it. I to full. By order 21072023. The records of CR case number 6050/2018 was called for from the Court of Granite Subdivisional Judicial Magistrate +1, Kamrup Metro, Guwahati. As the same within bracket as written, sort of one Kamrup Metro. Office notes reflect that the registry is yet to receive the said record. This a reminder to the Chief Judicial Magistrate, Kamrup Metro, Guwahati, as well as Planet SDJMS number 1, Kamrup Metro, Guwahati, for the records of said CR case number 6050/2018. Yes, I did not. Zero 03022023. Failure on the part of the authority concerned to provide the relevant records that was called for from the Court of Law and Sessions by the next date fixed. The court shall consider to pass consequential order against the carrying officer. Next. Matter also be placed before the Lozima Court pertaining to its report. For its report pertaining to service of notice taken on the respondent number 2 by registered post with AD on.
Lordship, respondent number 2 is appeared.
Oh, you have.
Then put respondent number 2.
What's your good name, ma'am?
N. Barua.
P. Sharma for respondent number 1. MS and Bora for respondent number 2. So, it's competent. Only people at top of the memo. List on 6th.
Keep your list.
Report of supplementary file.
May I please your lordship? Lordship may kindly peruse the order dated 31/7/2024 passed by the Lazima Court regarding the service of notice upon respondent number 2.
Pardon, Mr. M. Ahmed, counsel appearing for the petitioner. And Mr. P. Sharma, learned additional public prosecutor, appearing for the state opposite party number 1. Peruse the Lazima report dated 31/07/2020. Service of notice on the respondent number 2. Complete. Place this matter for admission after 2 weeks on a date to be fixed by the registry.
Interim order is there, lordship.
Interim order passed earlier on 16/06/2023. Shall remain in force until further order of the court.
Highly obliged.
May I please, lordship? Yeah, this matter, lordship, HA has been received together. Matter fixed for hearing.
Pursuant to the order of the court dated 28/08/2023. The record of special within bracket NDPS bracket close case number 20/2019 was called for from the court of Learned Special Judge within bracket NDPS bracket close Adalpuri. It is seen that the register have received the relevant records.
All respondent, lordship. But office note has maybe wrongly written.
Yes, why notice to be,
Very
why
first
registered post to be noticed?
not required, your lordship, in the first order, in the last paragraph, it has been written, no formal notice is required. But before that, in top, your lordship, top there, it's notice for issue, that's why maybe.
Your IA is pending,
No, sir, disposal. Disposal, I dispose.
disposed of.
Yes, lord.
of August,
Yes, my lord.
17. Private service report. List of the three needed to be fixed by the rules.
Highly obliged, my lord. I will go.
I might. I have to rise. I have a meeting at 4:45. People from this.
My lord, I'll be very brief, my lord, on that case. My lord, it is item number 36, my lord, if my lord is looking into that. My lord, we have taken the steps on the on the respond number 2, my lord. That office.
Respond number 2. So item 35 or 2.
30 may be taken on Monday.
36, my lord, is looking into this, no?
Just. Where is the office note dated N1 2024 and 17/8/2024?
Will
Matter
file
be
objection
placed-
money in amendment. In the meantime, my lord, we will file objection.
Matter be placed before the Lozima court for its report.
I may be allowed to take dust notice, my lord, if
on the respondent number 2 list on 9th of September.
it's your plate.